This is docket number 25-0037. It is a water-based rate case filed by Veolia Water Delaware, Inc. My name is Mark Lawrence. I'm the senior hearing examiner for the Delaware Public Service Commission. On January 15, 2025, Veolia filed its application for an increase in water base rates with the Commission. On February 19, 2025, the Commission entered order number 10645, which suspended the rate increase pending completion of a full investigation and evidentiary hearings into the justness and reasonableness of the proposed rates. Order number 10645 also set deadlines for intervention, appointed myself as the hearing examiner, and approved the form of public notice of the application to be published in accordance with 26 Delaware Code 102A. Valid notice was published by the company on February 28, 2025. Notice of the application was also published on the Commission's website on February 19, 2025. On March 4, 2025, the Division of the Public Advocate filed its statutory notice of intervention. There were no other parties who filed petitions for leave to intervene in this docket. A public comment session was held on June 4, 2025. No members of the public attended the public comment session. The public was also given the option of filing written comments. Eight written comments were received. All of those written comments were in opposition to the rate increase due to affordability concerns. On February 2025, Veolia filed a petition to implement an interim rate increase in the amount of $2,500,000 effective March 16, 2025, which was granted by the Commission. On July 8, 2025, the company filed for a second interim rate increase of $3,050,500, making a total of $5,550,500. On August 13, 2025, the Commission entered order number 10792, granting the company's interim rates to go into effect on August 15, 2025, subject to refund with interest, pursuant to 26 Delaware Code 306B. Valid notice of this evidentiary hearing was published on December 16, 2025. Notice was also published on the Commission's website. Our court reporter, Gloria, is taking down everyone's words during the hearing. I'm asking everyone to spell your names. Also, there are a lot of acronyms for contaminants in this case. And so I'm asking the attorneys and witnesses to please spell those for the record. Specifically, I'm referring to PFAS and MCLs and PFOAs, and it's just so that the record reads well for everybody. I'm asking that everyone please turn your cell phones off, and also that the witnesses speak into the microphones. When the microphone is out here, it really doesn't take, it's difficult to hear you in this room. So now I'm going to take appearances of the attorneys, and I'll begin with the company.
Good morning, Your Honor. My name is Shane Simon from the law firm of Saul Ewing on behalf of the company, and my colleagues are with me as well.
Morning, Your Honor. Pam Scott with Saul Ewing here on behalf of Veolia Water Delaware, Inc.
Good morning, Your Honor. Steve Genzer, Genzer, also from Saul Ewing.
Commission staff,
Kate Workman on behalf of Commission staff with co-counsel Stephen Ferguson.
public advocate,
David Crumpler, counsel for the Division of the Public Advocate.
okay. The company may call its first witness.
Did Your Honor want to address the partial settlement term sheet
Oh.
now or later?
Let's just address it now. Please state for the record, please address the partial settlement for the record.
Thank you, Your Honor. The parties have had the opportunity to negotiate prior to the commencement of the hearing today, and were able to resolve several issues. And those issues have been memorialized in a partial settlement term sheet, which I understand is in the process of being printed, but we would like to offer that as an exhibit to document the terms of the partial settlement, Your Honor.
And that will be marked as Exhibit 1.
Exhibit 1, Your Honor, correct.
Okay. And is that going to be admitted into evidence as Exhibit 1?
Yes, Your Honor.
Okay. Does staff agree?
Yes, Your Honor, staff agrees.
Does the DPA agree?
DPA agrees, Your Honor.
Okay. Is there an extra copy for, does everybody have a copy yet?
Your Honor, staff is printing it out right now so that everyone has a copy. All the parties have an electronic copy right now.
Okay. So if you could provide 2 copies to me once that's done.
Yes, Your Honor.
Okay. Thank you. Okay. So if the company would call its first witness now.
Thank you, Your Honor. The company calls Mr. Larry Finicum.
Today, the witnesses are going to testify from over here because it's a little crowded down here.
I do.
Good morning, Mr. Finicum. How are you?
Fine. Yourself?
I'm doing well, thank you. Mr. Finicum, Your Honor, may I approach the witness?
Yes.
Mr. Finicum, do you recognize the document I just handed you?
I do.
Can you tell us what it is, please?
Is the direct testimony on this docket served by myself?
And if I had reviewed the questions in that direct testimony with you today and asked you those questions, would your answers be the same today?
They would.
Your Honor, at this point, I'd like to move for admission of the direct testimony of Larry Finicum of Veolia Water Delaware, Inc., dated January 2025, into evidence as Exhibit 2.
Any objections, staff?
No objection.
PPA?
No objections.
It's admitted into evidence as Exhibit 2.
May I approach, Your Honor? Mr. Finicum, that second document I handed you, are you able to tell me what that is?
Yes, that is the rebuttal testimony that was written on this docket by myself.
And if I were to review that rebuttal testimony with you today and ask you the questions contained in that document, Would the answers to those questions be the same today?
They would.
Your Honor, at this point, I'd like to move for the admission of the rebuttal testimony of Larry Finicum of Veolia Water Delaware, Inc., dated November 2025, into evidence as Exhibit 3.
Any objections, staff?
No objections.
DPA?
No objection.
It is admitted, the rebuttal testimony of Larry Finicum is admitted as Exhibit 3.
Mr. Finicum, with respect to either your direct or rebuttal testimony, do you have any corrections to that testimony?
I do not.
Thank you, Your Honor. I have no further questions for Mr. Finicum on direct.
Staff?
May I pass out some papers to the parties?
Yes.
Thank you.
You gave me 5. Wait, 1, 2, 3. Give me 5. 6. Safety first.
Passed out cross-examination documents that staff may use. No guarantee we'll use all of them. I just want to be prepared so I don't have to get up and walk around for the rest of the testimony. You ready, Mr. Finicum?
And Ms. Warbeck.
All right. Your testimony states that the lead and copper rule program recovery should be embedded into the rate base, correct?
That's correct.
In your rebuttal testimony, on page 6, you reject Ara Azad's lead and copper rule. Is that correct? I have lines 14 through 20, page
That-
6.
That is correct.
What was that? ARAAZAD. Ara Azad rejected the lead and copper rule expense because they do not represent normal annual recurring expenses. Is that correct?
That is correct.
You disagree, and you state that the expenses are related to the company's compliance with mandatory service line inventory requirements. Is that correct?
That is correct, as related to LCRI, which requires notification to our customers for service lines that would either be A, lead, B, galvanized requiring replacement, or C, unknown service line material. Currently, as it states, the Delaware operation has approximately 28,500 customer side service lines that are of an unknown inventory. So that would be from the curb box into the house, and approximately 17,000 company side services where the material is unknown. So that would be from the water main to the curb stop.
Do you see PSC 1.9 in front of you?
I do.
Can you describe to us what that document is?
There are two documents before me. One is PSC 1.9, which is a data request related to Veolia's process and accounting for compliance with lead and copper rule improvements, also known as LCRI. And then I have another document before me that is, I believe, the same document with an updated 5/15/2025 informal request.
Yes, I believe we're going to focus on the original one.
The original. Thank you.
I wanted to have the updated one just in case. Does PSC 1.9, the original one, does that look correct to you?
Yes, it does.
Thank you. Your Honor, I would request that we mark PSC 1.9 for identification.
You just, staff just wants to mark it for identification purposes?
Right now.
Okay. It's marked for identification purposes. It will be exhibit number 4, marked for identification purposes.
Your Honor, would you prefer for me to move it into evidence now? I can do that, but the other parties haven't had a chance to hear what we're going to do with it yet.
Let's just mark it for identification purposes
Thank you.
for now.
Mr. Finnegam, if we look at your response to PSC 1.9, where staff asked about Veolia's accounting for compliance with the lead and copper rule improvements, the LCRI, which Jana Labella included as Exhibit JL-1 to her rebuttal testimony, you responded to staff in Subpart A. You start the response by describing Veolia's process for compliance, and then go on to specifically say to comply with the inventory portion of the lead and copper rule improvements, correct?
That's correct.
You also say the company has not deferred costs related to these activities, correct? We'll come back to the second part in a minute. Right now, we're going to focus on the costs related to the inventory portion of the lead and copper rule. Please refer to your rebuttal testimony, page 7, line 3 through 6. In which you state, pursuant to Title 40 of the Code of Federal Regulations, Section 141.86, the lead and copper monitoring requirements are ongoing, recurring, and cannot be considered unusual, correct? So in both your rebuttal and your discovery response, you stated the lead and copper rule improvements, the LCRI costs, are for compliance with the inventory requirement of the LCRI. Then you cite to Section 141.86, which is related to monitoring, correct? Before you, you should have the table of contents for this section of the uh, federal regulation, uh, 141.
Yes, I have it in front of me.
Looking at the table of contents for this section, the inventory requirements are under 141.84. Is that correct?
Could you repeat that once again, Ms. Workman?
Yes. So looking at 141.84, that is for the inventory requirements. Is that correct?
Yes, that is correct.
Thank you. So in your response to staff, and then on page 6 of your rebuttal, you discuss compliance with the inventory requirements, but then cited to the regulation that covers the monitoring requirements as a basis for disproving witness Ara Azad's concern that these costs should be removed from base rates. Is that correct?
That is correct.
Before you, you should have a copy of 40 Code of Federal Regulation 141.86, which you cite and interpret in your rebuttal testimony in pages 7, lines 3 through 6,
Objection to form.
Rephrase, please.
which is cited in your rebuttal testimony, page 7, lines 3 through 6. Can you point to me where in the Code of the Federal Regulations before you, 141.86, where in there does the code mention or reference the word cost?
Not the reference to the word cost in this document.
Just to confirm, nowhere in 141.86 is cost mentioned, correct?
Correct.
I mentioned earlier that we would come back to this statement. The company has not deferred costs related to these activities. That's what we're going to be referring to next. Are you familiar with Delaware PSC dockets number 24-0808 and 24-0951?
I am not.
Before you, you should have order number 10636 from docket number 24-0808. The order at pages 1 and 2 state the commission granted Tidewater's request to defer the costs associated with performing the inventory pending completion thereof and the adoption of any new regulatory mandates under the proposed lead and copper rule improvement. Is that correct?
That is correct.
Then on the third page, the order states that the commission approves Tidewater's proposed method of recovery of the amount within the regulatory asset via a temporary rate rider, correct? That's number 1 of the order section, right after now therefore it is hereby ordered.
Yes, that is correct. And I apologize. This is page 2 of my document.
I apologize as well. It's page 2 of my document as well.
But that is correct, Ms. Workman.
Thank you. So is it fair to say the commission ordered that in this case, Tidewater's costs associated with the lead and copper rule improvements compliance would be accounted for through a regulatory asset as a temporary rate rider?
Yes.
Can you please look at order number 10642? On the first page of that order, it states in that last whereas clause, Artesian was required to file with the commission a proposed method of recovery of the amounts within the regulatory asset no later than 45 days following the submission of the lead service line identification and inventory to the EPA, correct?
Correct.
And then paragraph 1 on the ordering paragraph on page 3, that states the commission approves Artesian's proposed method of recovery of the amount within the regulatory asset via a temporary rate rider. Is that correct?
That is correct.
Is it fair to say that in this order, the commission ordered Artesian's method of recovery to be a temporary rate rider?
Yes.
In the 2 orders that we just looked at, orders number 10642 and order number 10636, the LCRI is recovered via a rate rider mechanism, correct?
Correct for these 2 companies.
And even though the commission orders the lead and copper recovery investment, the lead and copper rule investment recovery via a rate rider in those 2 orders, you recommend recovery by including the cost in the rate base, correct? Generally speaking, so in general, would you agree that in order for the commission to establish a clear and concise record, it's important to accurately portray the arguments to which you are rebutting testimony?
Correct.
On page 7 and 8 of your rebuttal testimony, you state, on page 11 of witness Abba Azad's testimony, she notes that the company's PFAS testing is more frequent than the most stringent regulatory requirement of quarterly testing established by EPA and suggests that the company's testing is excessive and unnecessary. Is that correct?
Now, I disagreed with her statement in my rebuttal testimony.
But that is what it says. It says unnecessary, excessive and unnecessary. Is that correct?
The company strongly disagrees that the frequency of the company's PFAS testing is excessive and unnecessary. Is my answer to that.
All right, thank you. And then you go on to reference witness Ava Azad's recommendation on the subject. Is that correct?
You reference page and paragraph or page and line? Page 8. We're starting at line 5, correct? Through 6 through 7 to 8.
Give me a moment to. Page 7, line 20. That's in your testimony.
How does the company respond to the suggestion that any more frequent PFAS testing than required by the PFAS MCL is excessive and unnecessary? And my answer in my rebuttal testimony was really reflecting, Ms. Workman, the fact that Veolia is testing on a monthly basis to monitor for breakthrough on our vessels with the media. And that, absent of a streaming analyzer for PFAS, that is the best method to ensure that we're not having breakthrough or degradation on the media within our vessels. I believe what Mrs. Assad is referring to is the compliance testing that a water provider it needs to do as it relates to PFAS testing.
Thank
So
you, Mr.
yeah,
Finicum.
sure.
I found where I was looking for. I apologize. Page 8, line 5 and 6. Witness Ava Azad's recommendation on this subject. Is that what it says, correct?
It's correct.
In front of you, you should have a copy of Ava Azad's testimony.
I have it in front of me.
Where in Ava Azad's testimony does she say that the company's testing is excessive and unnecessary?
Mrs. Assad's testimony does not say that the testing is unnecessary
So just to be clear,
or excessive.
the words excessive and unnecessary are your words, not hers.
However, on page 11 of Mrs. Assad's testimony, she does reference the fact that in her estimation, the company's testing goes threefold beyond the most stringent regulatory requirement of the quarterly testing.
Does
So-
she provide an opinion on whether that is good or bad?
Objection to form.
Overruled.
Does she provide an opinion on whether the company testing more frequently than the EPA guidelines is good or bad?
She does not. She references the EPA standard and then also references that the states may set standards more stringent than that of the.
Can you point to where in Ms. Ava Azad's testimony she makes a recommendation on what the commission should decide?
Her testimony, there's no recommendation on what the commission should do.
Thank you. On page 9 of your rebuttal testimony, the question begins at line 14. You disagree with Ara Azad's assertion that the company did not complete any cost-benefit analysis related to the operational costs for the Stanton Water Treatment Plant. Is that correct?
That is correct.
Are you familiar with staff data requests 1.1 and 2.4?
Have them in front of me, yes.
And in staff 1.1, staff requested alternatives the company considered to the Stanton Water Treatment Plant upgrades. Is that correct? Staff also requested in 1.1 a description and supporting documentation of the cost-benefit analyses conducted by the company. Is that correct? And the company's response described no cost-benefit analyses, correct? So the company's response also didn't provide documentation of a cost-benefit analysis, correct? In front of you, you have staff 2.4, which asked for confirmation that no documents of cost-benefit analysis were provided, referencing back to staff 1.1. Is that correct? And the company, in their response, did not provide any of the requested documents. Is that correct?
That is correct as it relates to a cost-benefit analysis.
In front of you, you should have 26 Delaware Code, Section 207. In your understanding of the statute, just as a ordinary business person, that statute requires a utility to keep all their books and records, and that the parties are allowed to access and inspect those books and records, correct?
Objection, Your Honor. She's trying to get Mr. Finicum to interpret the law.
Your Honor, I'm simply asking his opinion as a lay person on this matter.
First of all, he's not a lawyer. I'll give him an opportunity to read it. No, if you can, if you'd like to make a comment, you'd like to testify about it. It's pretty straightforward, but if you're not giving a legal opinion about it.
Your Honor, can I ask for some clarification? Does he need to answer the question or not?
Well, I want him to be able to read it first. And, you know,
This is, just to be clear, this is subsection 208.
207.
207, excuse me, 207.
I'm going to, in light of my order yesterday, I'm going to sustain company's objection.
Thank you, Your Honor.
Would you agree or disagree that the parties that are reviewing Veolia's application in proceedings rely extensively on the responses to discovery questions that they ask the company?
I do.
And would you agree that it's important for the company to answer the discovery requests completely and that they try to assist to the extent reasonable? Would you agree that a cost-benefit analysis is usually important to determine whether a particular project is cost-effective?
Not necessarily, given the complexities of this project in particular. The alternatives that were looked at deemed infeasible on their face. And it would be my opinion that it would be a waste of both time and money to do any sort of formal cost-benefit analysis on alternatives that were not feasible in regards to quantity of water as well as quality of water.
So to be clear, you're saying that a cost-benefit analysis is not important to determine whether a particular project is cost.
Objection. The form is mischaracterizing his testimony.
Overruled. You can answer.
Depends on the complexity of the project or the problem that we're trying to solve.
Would you agree that it's important to consider alternatives to proposed projects that may achieve the same benefits as the proposed project but at a lower cost?
Yes, where that makes sense.
So in your opinion, as the regional president who's representing the company in this proceeding, do you believe that the responses to 1.1 and 2.4 were complete and thorough responses?
They were.
In your rebuttal testimony, again at page 9, the one that we were just referencing, that question that starts at line 14, where you were asked if you agree with witness Ara Azad's assertion that the company did not complete a cost-benefit analysis. You stated no, that you disagreed. So is that correct?
I'm going to object to the extent that this question is kind of rendered moot by your order yesterday with respect to the opinions on the analysis.
I would say that I'm simply asking him the same question that was asked in his direct testimony. So either he can speak to it or he cannot.
Objection overruled.
Again, Mr. Finicum, the question asked, do you agree with witness Ara Azad's assertion that the company did not complete any cost-benefit analysis? And you responded, no. Is that correct?
That is correct.
Let me ask you a hypothetical. Hypothetically, if a request was made for a cost-benefit analysis and then the company in the response did not provide the cost-benefit analysis, would you call that deficient?
No, given the fact that alternatives were looked at and deemed unfeasible. There were no other alternatives for us to pursue other than building the Stanton Water Treatment Plant PFAS building. So it makes the cost benefit analysis moot.
You said in your testimony that you disagree that the company did not do a cost benefit analysis. So did the company do a cost benefit analysis?
The company did not do a formal cost benefit analysis. The company looked at alternatives to the treatment of PFAS in our source water at our Stanton treatment plant. And that analysis, which is outlined in witness Fetcher's testimony, shows that the only path forward was to build the PFAS treatment plant.
Thank you, Mr. Finicum. I don't have any more questions. Your Honor, may I move that we put PSC 1.9 into evidence? We had previously marked it as Exhibit 4.
Any objection from the company?
No objection.
EPA?
No objection, Your Honor.
Okay, PSC 1.9 was previously marked for identification as Exhibit 4 is now admitted into evidence. Does the company have any questions?
Do we want to, I don't know if staff has any questions or, Some-
DPA?
EPA doesn't have any questions of this witness.
yes, Your Honor, the company does have some brief redirect. Mr. Finicum, do you recall Ms. Workman asking you about the LCRI?
No.
And you, for the record, the lead and copper rule improvements?
I do.
And so, do you remember Ms. Workman asking you questions about a distinction between monitoring and notification? Can you describe generally what Veolia does under the LCRI?
So under the LCRI, Veolia's approach is multifaceted as it pertains to our service line inventory that was submitted in October of 2024 per regulation. However, Veolia continues to enhance that inventory as we continue to survey our distribution system to ensure that all of our service line material, both customer side and company side, are known, as well as, and again, in my testimony, it talked about, all the multifaceted ways we do that. Also, the company is adhering to the LCRI regulation around notification to our customers that either A, have a lead service line material, a galvanized requiring replacement service material, or an unknown service material. And that is done annually by a letter, so a letter, an envelope, and postage for that. As well as Veolia continues to monitor through testing, through a triannual testing, giving our population the level of lead within our system. Right, currently under LCRI, it is 10 parts per billion, which was actually reduced from 10 parts per billion, which actually was reduced through LCRI from 15 parts per billion.
And the efforts that the company is undertaking to comply with the LCRI, does that cost the company money?
It does, both from internal labor. We have a multifaceted team of water quality professionals, operational professionals, and also operation technical professionals like GIS that help support the LCRI team, as well as we use outside vendors for the notification, the printing of the letter or the notification and the mailing of that notification to our customers.
So to confirm then, it sounds like both the notification requirements and the monitoring requirements require the company to expend funds. Thank you. Do you recall when Ms. Workman and you discussed Ms. Ava Azad's testimony concerning the threefold testing for PFAS? And I believe your testimony was that Ms. Ava Azad's testimony, and Your Honor, let me be clear. I mean no disrespect if I refer to the witnesses by their first name to clarify that, obviously, as they both have the same last name. So
That's why I did it that way in my order, because it was clearer just to use their full names.
okay, I just wanted to make that clear for the record. But with respect to Ms. Ava Azad's testimony, you recall discussing that with Ms. Workman, correct? And you don't, I think your testimony was that the word excessive and unnecessary were not in that testimony, right?
That is correct.
Do you have a copy of Ara Azad's testimony in front of you?
I do not.
Give me one moment. May I approach, Your Honor?
Yes.
Mr. Finicum, you do have a copy of your rebuttal testimony in front of you, correct?
I do.
And I'm going to refer you again to page 7, lines 15 to 20. And in particular, I'm looking at line 20. Can you read that partial line for me, please?
Required by the PFAS MCL is excessive and unnecessary.
Thank you. Can you refer to Ara Azad's testimony, specifically page 22, lines 6 through 8?
Yes, Veolia's spending.
One moment, Mr. Finicum. Yeah, thank you. I assume you're there?
In there.
Okay, thank you. And I want to clarify for the record that this particular portion of Mrs. Odd's testimony has been stricken, but in order to provide context for, at this point, what Mr. Finicum was responding to, I think it's necessary to ask him to clarify. So,
Object to the assertion that this portion has been stricken.
That's granted. That has to be worked out between the attorneys after today's hearing. I think rephrase
sure.
your question.
Mr. Finicum, were you responding to an opinion that Ava Azad had concerning the frequency of the company's PFAS testing in your rebuttal testimony?
May have been referring to Ara.
Ara Azad's testimony.
Yes, Ara Azad,
Okay.
giving what's written here. But also in Ava's testimony, the phrase threefold was utilized. And also excessive amount.
And is that what you inferred from Ava Azad's statement in her testimony? I don't have any further questions for Mr. Finicum. I'll redirect.
Cross staff.
No, we're good, Your Honor. Thank you.
DPA, any cross?
No, Your Honor.
Okay. Anything else with this witness?
No, Your Honor.
Okay. Thank you. Company may call its next witness.
The company calls Miss Gayla Fetcher, Your Honor.
I do.
Your Honor, may I approach?
Yes.
Miss Fetcher, the document I handed you, do you know what that is?
I do.
And can you tell us what it is?
It's a copy of the confidential version of my rebuttal testimony in this case.
And you prepared that testimony, correct?
I did.
The questions in that rebuttal testimony, if I asked you those questions today, would your answers change?
They would not.
Your Honor, at this point, I'd like to move this document into evidence, as I believe it's Exhibit 5.
Any objections, staff?
No objection.
DPA? Okay, the confidential rebuttal testimony of Gayla Fetcher is admitted into evidence as Exhibit 5. But before you get started, since there are confidential portions, are you going to ask any questions that pertain to the confidential portions?
I am not, Your Honor, and however, I spoke with Miss Workman, and she may have questions that implicate confidential portions of the testimony on cross.
The reason I ask that is because, there are a lot of people in the room and we are on Zoom.
Yes, Your Honor.
And so the confidential aspects of this are currently accessible by certain people, on Delafile.
Yes, Your Honor.
So before we got started with the witness, I just wanted to point that out to the attorneys. So Zoom's easy enough. We can turn that off. Certainly you can. The company and staff and DPA can do its cases whatever way it wants to do it. So, with that being said, please continue.
Thank you, Your Honor. Yes, I don't believe it's going to be an issue for my direct, but as noted, Ms. Workman may have cross that implicates confidential portions, and perhaps when that occurs, we could go off the record for a moment to determine the best course
Okay,
to deal with it, if that's appropriate, Your Honor.
sure.
Thank you. I believe this document has been admitted, correct? I'm sorry.
It's been admitted.
Thank you, Your Honor. Ms. Fetcher, if I were to, did you prepare direct testimony in this case?
I did not.
As part of your role in this proceeding, have you reviewed the direct testimony of Emily Guillen?
I have.
And are you prepared today to adopt that testimony as your own?
I can speak to her testimony.
Thank you. One moment, please. May I approach, Your Honor?
Yes.
For clarity, of the record, Guillen is spelled Guillen.
Ms. Fetcher, can you spell your last name, please?
I can spell my first two if you like. It's Gayla is my first name, and F is in Frank, Echer is my surname.
Thank you. The document that I just handed you, Ms. Fetcher, can you tell me what that is?
That is the direct testimony of Emily Guillen for Veolia Water Delaware, Inc.
And that is the document we've just been discussing, correct?
Correct.
At this point, I'd like to move for the admission of the direct testimony of Emily Guillen as Exhibit 6.
Staff has no objection.
DPA,
No objection.
the direct testimony of Emily Guillen is admitted as Exhibit 6.
Thank you, Your Honor. Ms. Fetcher, with respect to your rebuttal testimony, are there any corrections that you would make to that testimony today?
The only item I found was on page 2, line 8. Small correction, but I've worked for 24 years in the water industry, not 22.
Thank you for that. I don't have any other questions for Ms. Fetcher.
Ross,
Thank you. May I approach everyone and pass out some documents?
yes.
Thank you. You ready, Ms. Fetcher?
I am.
Would it be fair to say that on page 1 of your rebuttal testimony, you say that the water providers have a responsibility to carry out their duties in a manner that keeps costs reasonable for customers?
That is correct.
You also state on page 1 of your rebuttal testimony, it's my responsibility to ensure that all capital investment across the Mid-Atlantic region technically and cost-effectively addresses these duties within regulatory and internal governance parameters. Is that correct?
That is correct.
And on page 3 of your rebuttal testimony, you state that one of the purposes of your rebuttal testimony is to explain the company's extensive internal and external analyses in developing a strategy to manage PFAS in drinking water. Is that correct?
That is correct.
On page 4 of your rebuttal testimony, you reference the company's robust internal governance and decision-making process around the Stanton Water Treatment Plant. Is that correct?
I'm sorry, which line are you referring to? You said page 4?
Yes, page 4, line 18 and 19. It says the company's robust internal governance and decision-making process around the Stanton Water Treatment Plant. Is that correct?
The company does have a robust internal governance and decision-making process around the
Yes,
facility.
so you would agree with that statement.
Yes.
Okay. On table 1, which is found on pages 20 or 12 through 20 of your rebuttal testimony, you list a number of federal and state actions that influenced Veolia Water Delaware's Stanton Water Treatment Plant PFAS project, correct?
Objection. For the record, the table 1 is from pages 12 to 18.
He is correct. I apologize. And then, as you state on page 5 of your rebuttal testimony, this is a chronology of relevant federal and state regulatory actions concerning PFAS that influence the company's decision to design and build the Stanton Water Treatment Plant. Is that correct?
To address PFAS, correct.
The first row of that table lists federal action regarding PFAS compound PFOA dating back to February 2008, correct?
It does, yes.
And then the subsequent actions listed in the table include actions from 2009, 2012, 2013, and then every year from 2016 to 2025, correct?
Yes, it does have every year from 2016 until 2025.
So, of the actions listed in Table 1 of your testimony, which actions do you believe established legally enforceable requirements for the company to treat PFAS?
Objection calls for a legal opinion.
The witness in her testimony states descriptions of the particular laws that are described, and she also provides opinions on the applicability of the regulations guiding their decision to build the plant, when and how they did. So it's already in her testimony. Either we would agree to strike it from the testimony, or we would be happy to have the witness answer the question.
Company?
Your Honor, in her testimony, she states that these are part of a number of factors that influence the company's decision to construct the plant. She's not opining on the enforceability or lack thereof of any single one of these regulations. She's simply documenting what occurred. She's not offered as a legal expert. She's not offering a legal opinion.
She describes the regulatory landscape. She offers the company's view of the regulatory landscape. She talks about how the regulations are a primary driver of the regulations.
From an engineering perspective, Your Honor.
It's not from an engineering perspective. She does not talk about building, brick and mortar, none of that.
She's included 6 pages in a table that's entitled Summary of PFAS Regulatory Environment Influencing Veolia Water Delaware. So either she testifies to it or it's stricken.
Is Your Honor suggesting that Ms. Fetcher should provide legal opinion as to the enforceability of the statutes. I just want to clarify the scope of the permissible questioning.
She needs to testify to the extent that she can. She's included it in her testimony. There are plenty of things in here that she can testify to. I mean, there's descriptions, when things were published, what they are, regulatory event. Those aren't legal things. They're, a regulatory event is, for example, in 2008, proposed U.S. EPA drinking water contaminant candidate list 3 draft. You don't need to be a lawyer to understand that. And then it says chemical concentration, PFOA. In the description, EPA seeks comment on its proposed decisions to include PFOA on the draft. That's the choice that Ms. Fetcher has. Either she testifies as to the 6 pages in her table, or it's stricken.
Okay, I think I understand that clarification, Your Honor. My objection is just more limited to the extent that Ms. Workman is asking for Ms. Fetcher to interpret any particular statute or regulation. I would just object to that. I'm more than comfortable with her explaining why she included what she did. That's perfectly permissible testimony.
Okay, I think we're on the same page.
Okay, thank you, Your Honor.
Yeah, I certainly don't want her to interpret legal things or anything along those lines.
Thank you, Your Honor.
She can only testify as to what she knows.
Your Honor, it's perfectly acceptable for an I don't know. If
Sure.
we get an I don't know, we can move on.
Sure. Okay.
Again, Ms. Fetcher, of those actions listed in Table 1 of your testimony, which actions do you believe establish legally enforceable requirements for the company to treat for PFAS?
The information in the table is included as it demonstrates that PFAS would ultimately become enforceable. So in 2008, when USEPA added PFOA to the contaminant candidate list, that is a sign to water purveyors that there is a contaminant that is not yet regulated, that data indicates is of damage to human health and could be a damage for public consumption. When we go to 2009 and they have health advisory limits, that further validates that ultimately PFOA and PFAS are going to have enforceable limits. And as water suppliers, we need to be aware that those regulations are coming down the track, because to achieve compliance does not happen overnight. It requires planning, it requires budget allocation, it requires a lot of time and money to get to the point where you are achieving those compliance factors. Ultimately, hold on. For the Stanton facility in Delaware, I believe the initial compliance item came in 2018 when DENREC issued the policy for sampling and evaluation. That wasn't compliance for concentrations going out the door, but it's compliance for activities that require costs to be attributed and that to define PFAS within our facility. The action plan in 2019 was an indicator that MCLs were coming and that there would be enforceable limits. beyond the health advisories that were already issued. And then there was then the strategic roadmap by US EPA in 2021 that had proposed MCLs that were an indicator of what the enforceable limits might be. Delaware swiftly followed with their House bill later that year saying regulations are coming, and within 9 months of the effective date of this act, they would have public hearings that would then lead to a regulation. And no less than 6 months later, there was an implementation plan that said that was going to be enforceable from 6 months, no, sorry, a year thereafter. If you were in excess of the MCL that was posted, they were going to require immediate corrective action. So everything in this table ultimately led to PFOA and PFAS concentrations that were going to be enforceable, and we could take it all the way through the end of the table.
So your testimony is that all of those are, to your understanding, legally enforceable.
Same objection to that term, Your Honor.
Sustain.
It's your understanding that the company had to comply with all of those regulations or all of those items listed in the table.
It was the company's understanding that we were ultimately going to have to comply with PFAS regulations, but it was a very dynamic environment that was developing. All we could see was that as more data became available about PFOA and PFAS, regulations were coming down and timelines for compliance were getting quicker. So ultimately, the enforceable component was the contaminant itself. And all of these policies ultimately led to that point, either at the state or federal level.
Thank you. Your Honor, may I pass out one more thing?
Yes.
Ms. Fetcher, in front of you, what I just handed is 42 U.S. Code Section 300G-1. It's highlighted where that first one.
Yep.
On the first page. Can you go to the second page and please read the highlighted portion of that for us?
Section F, health advisories and other actions. The administrator may publish health advisories which are not regulations or take other appropriate actions for contaminants not subject to any national primary drinking water regulations.
So would it be fair to characterize that paragraph that there are some state and federal actions regarding the safety of drinking water that are not legally enforceable?
Objection calling for the witness to interpret the statute, Your Honor.
I'm asking for her to give her understanding of the small paragraph she just read, not give me an in-depth interpretation.
Overruled.
My interpretation of this paragraph is that there are health advisories in place for contaminants. They may not be enforceable by violations, but that's what the paragraph says to me.
Thank you, Ms. Fetcher. Going back to table 1 in your testimony, what compliance actions were required of the company in those actions that are listed in table 1?
At this point, the requirements were for sampling both at the state and the federal level. There is nothing yet. If we still had PFAS going out the front door, we would not be in receipt of any violation at this time. However, come 2 months from now, if we were to have PFAS samples going out the door, there would be consequences for the state of Delaware.
So in light of the information provided in table 1 in our discussion today, is it fair to characterize the company's decision to move forward with the Stanton Water Treatment Plant upgrades with proposed and not yet final PFAS regulations as motivated by a sense of urgency?
I'm sorry, could you repeat that one more time?
Yes, so given what we've just been discussing and table 1, I apologize. The PFAS treatment plant upgrades, when were motivated by a sense of urgency given the regulatory landscape.
That was certainly part of the motivation. The ultimate trigger, however, was, hold on, if we refer to my testimony, on page 22, starting at line 1, the DPH had issued an MCL implementation plan that was indicating forthcoming compliance approximately 9 months later. And as an operation, we had sent a letter to the DPH highlighting the challenges with the timing that they indicated they were going to implement for compliance. But that was ultimately the trigger for the project. And we knew at that time that spring 2023 was not necessarily going to be achievable, but the project was initiated as a good faith effort, hoping that progress towards compliance with the expected MCLs would provide some latitude in the ultimate deadline with the lack of response from DPH.
Ms. Fetcher, on page 21 of your rebuttal testimony, in response to that first question, I'm looking on, beginning on line 4 there. You say when the EPA issued the PFAS action plan in early 2019, the company began to consider how to reduce PFAS concentrations at the Stanton Water Treatment Plant. Is that correct?
That is correct.
And then on page 20 of your rebuttal testimony, you state, and I'm looking at line 10, page 20, line 10. You state in late 2021, it was clear EPA or Delaware or both would soon establish mandatory MCLs for PFAS based on the timeline of actions showing that the federal government in several states continually established lower and lower concentrations of PFAS for public safety. Over time, the company concluded that any final MCL would likely be lower than what Delaware had proposed in 2022. Is that correct?
That is accurate.
And then on page 22 of your rebuttal testimony, I'm looking at line 19. You state sampling at the Stanton Water Treatment Plant intakes began in 2017. The PFAS treatment facility project was kicked off in spring of 2022 and was placed in service in March of 2025. Is that correct?
That is correct.
Your Honor, at this time, I have one question for the witness that implicates confidential information. And so I would request that you be allowed to ask that question in confidence.
Okay. I need any of the people that are in the room that do not have access to confidential information in this case to just step outside the room for a short amount of time. I also need a Zoom DPA.
No questions from the DPA, Your Honor.
Okay.
Oh, Your Honor, I'm sorry, we were not done with our cross. We were done with the confidential portion.
Okay, continue. Sorry.
Thank you.
Sorry about that.
Ms. Fetcher, in front of you, you should have PSC 1.1. One of the documents I handed over at the very beginning.
I do.
And do you recognize that document?
I do.
And to the best of your knowledge, is that document correct?
It is.
Thank you. Your Honor, I'd like to mark the PSC's staff 1.1 for as an exhibit.
Okay, this is entitled the Delaware Division of the Public Service Commission first set of data requests directed to Veolia Water Delaware Inc. PSC-1.1 Gillian. Any objection, company?
Objection.
EPA?
No objection.
Okay, that document is admitted as Exhibit 7 into evidence.
So on PSC 1.1, Ms. Fetcher, staff requested the alternatives considered to comply with PFAS regulations, correct?
They did.
And they PSC 1.1 also requested documentation of that as well.
They did.
And the company's response states that no alternatives were investigated beyond initial identification as they were immediately determined to be infeasible, correct?
It does say that, yes.
And in response to that, the company provided no documents. Is that correct?
As it relates to any detailed alternative analysis, yes.
In front of you, you should also have a copy of PSC 2.4. Are you familiar with this document, Ms. Fetcher?
I am.
And to the best of your knowledge, is that a true and correct copy of it?
I believe so.
Yeah, okay. Your Honor, I'd like to mark this for an exhibit.
Okay, this is a PSC 2.4. Any objection, company?
No objection.
DPA?
No objection.
Okay, PSC 2.4 is admitted into evidence as Exhibit 8.
So in PSC 2.4, staff asked the company for documentation of the alternatives considered to comply with the company's understanding of PFAS regulations. Is that correct?
Say that last piece one more time. They asked for,
They asked for documentation of alternatives considered to comply with the company's understanding of PFAS regulations.
they asked for documentation of alternatives to address PFAS.
Okay. And in response to that, the company provided no documents, correct?
They did not provide any cost benefit analysis documentation associated with the alternatives considered.
Thank you. Outside of rebuttal testimony, the company has not provided documentation in this case to support that it consider alternatives to the stand water treatment plant upgrades for PFAS treatment in advance of its decision to move forward with the plant's design and construction. Is that correct?
Objection to form.
Would you read the question back? Overruled. You can answer.
The PSC documents that were just reviewed would indicate that I wasn't involved as much in the original testimony. So I don't think I can speak to of everything that has been submitted over time.
Okay. To the best of your knowledge, though, no documents have been provided for that.
No detailed cost benefit analyses have been provided.
And to the best of your knowledge, does documentation of alternatives to the PFAS treatment plant exist?
Not detailed alternative analyses, no.
Thank you. Does any documentation of the impact of the PFAS treatment plant on customers from before the decision to upgrade the Stanton Water Treatment Plant exist to the best of your knowledge?
Objection to form. I'm not sure what impact means in that context.
Of the cost impact to the customers?
That would be an evaluation outside of my purview.
Okay, so you don't have knowledge of that.
I can't speak to whether or not it was done or not.
Okay, thank you. So before we had discussed your role in your responsibility as the we had discussed your role as in the company that you are responsible for uh, capital investments, and that part of your role there is to address um, the cost effectiveness. Let me rephrase. You said you're unaware of the documentation of the impact that the PFAS treatment plant would have on um, customers in terms of affordability. Um, but your role, as you described in the first page of your testimony, indicates that you are responsible for all capital investments in the region. So why are you unaware of if that documentation exists? If you're the one who's in charge of these capital investments, um, why are you unaware if those documents pertaining to the affordability of the PFAS treatment plant upgrades, if uh, there's any analyses that happened before the decision to upgrade the plant exist?
Objection to form and objection. I believe it's mischaracterizing the witness's testimony. She said that was outside of her purview, not she was unaware of documents.
Sustain.
So you state on page 1 of your rebuttal testimony, it is my responsibility to ensure that all capital investments across the Mid-Atlantic region technically and cost-effectively address these duties within regulatory and internal governance parameters. Is that correct?
Yes.
But you are unaware of documents that the company may or may not have regarding the cost impact to customers that happened before the decision to upgrade the Stanton Water Treatment Plant. Is that correct?
Yes. Perhaps it would serve, though, to clarify what the cost effectiveness in the first page of my testimony actually does. Prior in that paragraph, we discuss how our responsibilities are to provide a reliable and uninterruptible supply and to ensure that that supply is safe for public consumption. PFAS isn't safe. So we knew that we had to do something about PFAS and that it was going to require a large investment. My job as director is to ensure that the money that we are spending on that installation that is required for the safety of public consumption is done so as cost effectively as possible with the most while also providing operational flexibility, operational sustainability, while also addressing the other needs of our system. I think any water utility would tell you that the prospect of PFAS is inherently unaffordable, and the challenge we face is by implementing these solutions as cost effectively as we possibly can. So it's that cost effectiveness, the allocation of capital expenditure, and ensuring that once that allocation is made, every effort is made throughout the process to optimize costs and implement the best possible solution. That is the cost effectiveness realm that falls at my responsibility.
So what documents does the company have that demonstrate analysis of the cost effectiveness of the upgrades to the Stanton Water Treatment Plant in terms of for treating PFAS and related substances? What documents does the company have to indicate these costs were considered prior to the decision to upgrade their system?
Objection asked and answered.
Overruled.
As part of my responsibility to adjudicate capital, it is also my responsibility to bring together the best minds in our business and the best minds in our water arena, and discuss whether a project is even viable to move forward for study. If we wanted to pay $100,000, $200,000 to investigate all alternatives for any projects that we possibly want to do that reach out to the farthest possible parameters of our geographic region, that would not be a prudent expenditure. If you look at
Ms. Fetcher, if we could just return to my question. My question was,
Objection. She needs to finish her answer, Your Honor.
she's not answering the question. She's
I am.
going on.
I am.
Please allow her to finish her answer.
If you look at Table 2, that presents the 5 alternatives that we possibly had to not treat for PFAS at the Stanton facility. There was no third-party study, no detailed cost-benefit analysis, no multi-day workshop with documented meeting minutes that would have changed the conclusion of each one of those alternatives. There was no alternative that guaranteed the capacity that we needed to supply water to the customers of Delaware. There was no alternative that would have been more cost effective. Any new surface water treatment plant, you're looking at $8 to $10 a gallon to put in a new surface water facility, especially, and that's after you spend the time and the years to get your allocation, to do the land acquisition that you possibly have to do, to coordinate with the customers and the townships to see if you can possibly build in that area. With groundwater, those locations can take 1 year just to develop a single well. And we were going to be looking at maybe having to do 30 with no guarantees that there wouldn't be needed PFAS treatment there as well. There was no way in looking at these alternatives to see that they were viable enough to consider a detailed cost-benefit analysis for their applicability as opposed to treatment at PFAS facility. So there is no documentation because it would have been an imprudent, wasteful spend of money to draw the same conclusion that there were no alternatives to treating at Stanton.
I think I don't need to proceed with that line of questioning anymore. We're going to switch gears a little bit. On page 52 of your rebuttal testimony, I'm looking at line 8. You stated that as of the date of this rebuttal testimony, the pilot has been running for almost 500 days, and there has not yet been a full media replacement through lead and lag vessels, correct?
That would have been correct, yes.
On page 52 of your testimony, I'm looking at line 16. You said the pilot results and full-scale sampling to date indicate that the change-out frequency, and that's the change-out frequency of the PFAS media, is still unknown. Is that correct?
Correct.
In front of you, you should have a copy of company witness Cagel's direct testimony in Veolia's last rate case, 23-0598.
I do have that in front of me.
Thank you. Can you turn to page 6, line 19? And Mr. Kagel estimated that the PFAS O&M costs would be about $6 million. Is that correct?
Yeah.
Now, originally, the PFAS O&M costs submitted in this case for recovery were estimated to be about $5.1 million. Is that correct? I believe you say it on page 65.
Yeah, it's that.
Yeah, page 65, line 11. So that 5.1 million was the initial estimate, correct?
Yes, and it's also detailed on the following the table on the following page.
And then the rebuttal testimony said that the estimated cost went down to 3.5 million annually. Is that correct?
That is correct.
What changed to decrease the estimation from 5.1 million to 3.5 million?
There were two things that have changed. If you're looking at table 8 on page 66 of my testimony, under changed assumptions, we built the facility with 21 skids, 42 vessels in total, in order to accommodate the full 30 MGD capacity. And recognizing that trying to get extra vessels in after the building already built would create much more expense, we elected to install all 21 skids at the beginning. However, we selected not to put them all in service because our peak hour falls somewhere between 23 and 25 MGD. Even though that's higher than our max day, our peak hour does get that high. So we only put 40 vessels in service instead of 42. And then through competitive bidding and RSSCT testing, as well as subsequent pilot testing, we changed the media type to be used from F400-01 to F400, which created a subsequent reduction in the unit cost in dollars per pound of the carbon being changed out.
Thank you. And so in that table that we were just referencing, table 8, the costs changed because the assumptions underlying them changed. Is that correct?
Correct.
And of that 3.5 million annually that we had discussed earlier, what portion of those occurred during the test period for this case?
None.
Thank you. On page 6 of your testimony, I'm looking at line 26. You state that section 3 of your testimony addresses several considerations, including balancing compliance with cost, correct?
Correct.
So please turn to page 20, which is where section 3 begins. I'm looking at section 3, pages 20 to 22. Would you please read the language that demonstrates Veolia's cost considerations about how the company balanced compliance with costs?
That wouldn't be appropriate to do in that section because this section is speaking primarily to the drivers to needing to execute PFAS, a PFAS solution at Stanton.
Are there references in this section to other sections regarding consideration of the costs or impacts on ratepayers?
The references in this section are focused primarily on the triggers to initiate the project, of which cost wouldn't have been a consideration, public health would have been.
But the purpose of that section that we established earlier, one of the purposes was balancing compliance with cost. So is that a part of that section or not?
The purpose of that section, as stated on line 16 of page 20, is to highlight the primary drivers for VW Delaware to consider PFAS treatment at Stanton.
So since cost balancing compliance with cost is not mentioned here, does that mean that one of the primary drivers to consider PFAS treatment at Stanton was not cost?
The cost considerations came into play, like I mentioned a few moments ago, when we were discussing what the potential alternatives were to doing treatment at Stanton. Cost also came into play in the selection of possible treatment technologies. And then cost was 100% considered over the full life of the project with all the progress workshops, all the subject matter workshops, all the multifaceted evaluations of bids, the competitive bidding and testing of the media, that all of those things discussed in a subsequent section. I think it is, hold on, section 6. Right section.
Ms. Fetcher, my question relates to
Objection, she's answering the question, Your Honor.
Were you done with your answer?
All the cost evaluation and the prudency and how we reduce cost is primarily focused in section 6.
so section 6 on page 7. I'm looking at line 14, page 7 of your rebuttal testimony. You say, I explain how the company took a collaborative approach to ensuring the Stanton Water Treatment Stanton Water Treatment Plant project proceeded in a timely and efficient manner. So that section refers specifically to the building of the Stanton Water Treatment Plant. Is that correct?
The development of the whole design and operation, it wasn't just the building of the building, it was the selection of treatments, it was looking at feed concentrations to see if there was any optimizing there. It was running the pilot, it was optimizing labor, it wasn't just building a building.
And all of that happened, all of those cost considerations described in section 6 happened after the company's decision to proceed with upgrading the Stanton Water Treatment Plant, correct?
Everything decided in section 6 is post move forward with treatment. Yeah.
So section 3 is the section that deals with prior to the decision to proceed with the construction of the Stanton Water Treatment Plant. And so is it fair to say that in your testimony on those 2 pages that there is not a discussion on balancing compliance with costs that was considered prior to the decision to proceed with the construction of the Stanton Water Treatment Plant with the upgrades?
Yeah, in section 3, there's no discussion of cost. The evaluation of costs really came in when we considered alternatives and when we were executing the project.
So before that, cost was not a primary concern, correct?
Objection to form.
Overruled.
I disagree. Cost was always a concern.
Your rebuttal testimony in the section that we were just looking at does not indicate that cost was a concern. Is that correct? In those 2 pages, section 3 that we were just discussing, it does not discuss cost as a concern. Is that correct?
I would argue that while cost may not be discussed in section 3 of the rebuttal testimony, as indicated in the summary, it was most certainly a consideration way before the project was initiated. We plan all of our improvements and investments on a 5-year time frame. In 2019, we were already talking about this project, and we actually installed tees into the only footprint we had left on the facility should the need for PFAS treatment arise. So that way we could save costs with the ultimate connection. So before we had even developed an action plan for PFAS at Stanton, we were taking cost-saving approaches in order to expedite implementation 3 or 4 years before it even came a thing. So we have always been thinking about costs for this project and how we can possibly do it more effectively. The fact that my summary says that it was mentioned in section 3 and it wasn't mentioned section 3 doesn't mean that it wasn't considered.
But as we established earlier, to the best of your knowledge, the company has not provided any documentation to support that.
That's not what my testimony earlier said. My testimony earlier said that while there may not have been detailed cost analysis documents provided, that was because the alternatives to PFAS treatment that were available were evaluated by a very professional team and deemed that they were not viable before we even got to a detailed study stage. So the preparation of documentation and the lack of submittal to the PSC of a detailed cost-benefit alternatives analysis does not determine that cost was not considered.
Your testimony, especially on table 1, goes into the years-long history of the federal and state actions regarding PFAS contamination in drinking water, which dates back to at least February 2008. but the company can't produce any documents to support it consider alternatives or the impact to ratepayers before committing to a capital expenditure that was projected to cost over $43 million. Is that correct?
Can you restate the question part of it?
Yeah, so the first part is the company was aware of PFAS, state and federal actions regarding PFAS as early as 2008, as indicated in Table 1 on your testimony. And the company has, to the best of your knowledge, not provided staff who requested it in PSC 1.1 and 2.4. They have not provided staff any documents to support that alternatives were considered or the impact to ratepayers were considered before they committed to an expenditure that was projected to cost $43 million. Is that correct?
Objection asked and answered.
Overruled.
Just because we had more years before we finally had to move on the project does not mean that we then should have progressed with studies that could have cost several hundreds of thousands of dollars to confirm something that we knew based on our good judgment, based on our engineering knowledge, based on our knowledge of the area. So the fact that we've been tracking regulations since 2008 doesn't mean that we should have hired geotechnical companies to investigate groundwater supplies around the state. And we should have started 2-year sampling programs on the Brandywine or on the Christina River to really understand what levels of treatment we would need there for all contaminants should we add that as a new source of supply. The time frame of the regulations doesn't necessitate spending the money on those extra analyses when the outcome would be the same. That treatment at Stanton is and would have been the most cost-effective option to provide safe drinking water to our customers.
I'm asking for a yes or no answer. Either what I say is correct or it is not correct. So yes or no, the company has not produced to staff a single page of documentation to support that they considered alternatives and the impact to ratepayers before committing to spending this $43 million on the Stanton Water Treatment Plant upgrade.
I don't know if that's true, but I do know that it was included in testimony in our rate case in 2023. I know there was an extra memo that was included in the finding of that rate case identifying that the project was going to happen. I'm not the right person to ask the questions about that stuff, but there was definitely documentation given to the Utility Commission about this project and its necessity prior to doing it, and it was discussed in meetings with the Utility Commission too. But I can't speak to the full quantity of boxes of documentation that have been submitted as part of this rate case.
Thank you. Your testimony on page 57 at the very top says that you address PFAS O&M testing costs. That's at the bottom of 56, along with company witnesses Labella, Hatch, Cosgrove, Murray, and Finicum. Is that correct?
That is what my testimony states, yes.
So the company has provided rebuttal testimony of 6 different witnesses to address the one issue of the out-of-test period PFAS O&M costs. Is that correct?
It would appear so. Mhm.
Thank you. Now, the PFAS O&M expenses, are they expenses that will continue to be expenses throughout the life of the Stanton Water Treatment Plant?
As long as PFAS is regulated, yeah.
Okay. So those costs will not go away, and they will instead become a normal operating expense for the company?
Right.
Thank you. I have no further questions.
DPA,
No questions from the DPA.
redirect?
We take a short bathroom break, Your Honor.
Sure.
Thank you.
Okay, back on the record. Redirect by the company.
Thank you, Your Honor. Ms. Fetcher, can you take a look at page 26 of your rebuttal testimony for me, please? I'd like to ask you some questions about those pages. Looking at pages 26 for the next couple pages, specifically the Q&A on page 26, lines 8 through 11, you refer to an alternative analysis there. Do you see that?
I do.
And is that alternative analysis you're referring to, was that the alternative analysis that would have been performed prior to the decision to construct the plant?
Correct.
And as part of that, if you look at it's lines 17 to 22, do you discuss cost there?
I do, yes.
I'm sorry, Shane, can you repeat those page number and lines for me?
Sure, I'm referring to page 26, lines 17 to 22.
Thank you.
And Ms. Fetcher, going to page 30 of your rebuttal testimony. Can you tell me what's on page 30 of your rebuttal testimony?
It is a summary of the alternatives to treatment at Stanton Water Treatment Plant that were considered.
And this relates to the alternatives that were considered prior to the construction of the plant, correct?
Yep, and the section you just read.
Thank you. And in this table, does it discuss cost at all? Or
It does.
can you tell me where?
Well, so in the sections regarding water quality, it insinuates where elevated costs may be required to institute either PFAS treatment or treatment for other contaminants of a new source. Under the location column, it discusses additional infrastructure improvements beyond bringing the new source online that would be required to use that new source for distribution throughout our facility. And then in the determination column, it makes references to costs in terms of whether it's viable or not viable.
Thank you. And so with respect to table 2 and the rebuttal testimony that both precedes it and follows it relating to the alternatives considered with the company, can you tell me whether the company did consider cost as part of that alternatives analysis?
We absolutely did.
And the company considered other factors as well, right?
Yes, we did.
Your Honor, may I approach?
Yes. The company is marking as, for identification purposes only at this point, a document entitled PFAS, a dangerous and widespread contaminant. Oh, well, you know what? Let me strike that. It's a document, Senate Bill 72, Empowering Communities Against PFAS. And it's issued by the Delaware Health and Social Services Division of Public Health. Okay.
Thank you, Your Honor. Ms. Fetcher, can you take a moment to review this document, or perhaps you already have?
I have seen this before, yes.
Okay, can you tell me what this is?
It is a summary of the content and intent of Senate Bill 72.
And earlier, when you were discussing Table 1 in your rebuttal testimony with Ms. Workman, was Delaware Senate Bill 72 a component of Table 1?
Yes, it was.
And earlier, I believe you testified that PFAS was a safety issue as well, correct?
I did.
Does this document contain any information concerning the safety aspect of PFAS?
It does. On side 2 in the center column underneath the title PFAS, a dangerous and widespread contaminant, it discusses the health effects of PFAS, including cancer, infertility, low birth rate, liver damage, reduced vaccine effectiveness, weakened immune system, high cholesterol, and hormone suppression, to name but a few.
And if you turn to the other side of this document that has the Senate Bill 72, Empowering Communities Against PFAS language, in the leftmost column, there is a heading, Senate Bill 72, Promoting Transparency and Early Action. Do you see that?
I do.
Can you please read that aloud?
SB 72, Promoting Transparency and Early Action.
And
Federal,
continue, please.
Federal guidelines require public water systems to begin testing and monitoring of PFAS by April of 2027 and MCL compliance by 2029. However, SB 72 encourages water providers to take action far sooner. As our customers, it's important for you to stay informed about our water quality. Here are a few ways that you can access information, and it provides a bunch of links. One for water testing results of local utilities. The second is the Office of Drinking Water website for any PFAS-related tools, and being on the lookout for any public notices that we send as your drinking water provider.
Thank you. So in terms of your testimony earlier referencing Senate Bill 72, and I think you used the word urgency to take action, was this also something that the company was considering as part of its decision to build the Stanton Water Treatment Plant?
Senate Bill 72 certainly reflects the spirit in Delaware as it relates to PFAS. But while the Senate bill was really only introduced in March 2025, at which point we were ready online, but it reflects the similar sentiment of the DPH MCL implementation plan that was issued in February 22.
Thank you. Returning to your discussion concerning the costs of the plant with Ms. Workman, do you recall whether this project hit budget?
We came in 20% under budget.
Does that total to a dollar figure?
Yeah, hold on. On table 4 of my testimony, which is found on page 42, our budget was 43.3 million and our actual expenditure was 34.6, which is math. I cannot do that quickly. Is that 8 point? It's like 8.7 million. That the right math?
Thank you. And in terms of You talked a lot about cost effectiveness. In terms of evaluating the cost effectiveness of a finished treatment plant, is there some metric that can be used to evaluate that that's discussed in your testimony?
There are several metrics that can be used that are discussed in my testimony. One is where the project lands compared to budget. Another is the percentages of change orders you have over the cost of the project. Another is looking at our multifaceted bid evaluations to make sure we were selecting best value across the board. So for the cost effectiveness of a project, it's usually budget versus actuals, percent change orders, and speed of delivery.
Is treatment cost per gallon another factor that's considered?
It is indeed.
Can you tell me a little bit about that?
So any type of installation, any type of project, when you're looking at ways to categorize how much it might cost utilities to implement those solutions, they're usually evaluated in a cost per gallon. Black and Veatch partnered with AWWA to evaluate the cost per gallon of implementing PFAS treatment. Their most recent document, which is where's that exhibit? It's included in exhibit GF1. It's called Estimating the National Cost to Remove PFAS from Drinking Water. And it's discussed on page 54 of my testimony. The study found that the estimated capital cost to construct a GAC facility to treat PFAS was $2 per gallon for a 10 MGD facility, with a projected linear increase in cost as capacity increases. So as a 30 MGD facility, it could be anticipated that to construct a GAC facility to treat PFAS would have cost more than $2 per gallon. At this project, we came in at $1.2 per gallon.
Thank you. I'm going to refer to the document that Ms. Workman previously showed you. It's Title 42, Section 300G1. Can you pull that up for a moment, please?
I have it.
Ms. Workman asked you specifically, it's on the second page of this document, but it's the highlighted subsection F. Do you recall that?
I do.
Can you, excuse me, could you please take a moment to review subsection D, which is immediately before that? Let me know when you're done.
Okay.
Can you then read subsection E that is immediately before subsection F?
Okay.
In terms of the length of time it took the company to proceed with the construction of the plant, I imagine that's not something that could occur in a relatively quick fashion, right?
No,
And in terms of the regulations and the regulatory environment you were referring to in table 1 of your testimony, can you elaborate a little bit as to the process, why the company made the decision to proceed when it did?
the company made the decision to proceed when it did in February 2022, when the Delaware Department of Public Health issued the PFOA and PFOS MCL implementation plan. And subsequent to that, we wrote a letter to the Office of Drinking Water requesting reconsideration for the timeline that was left unresponded to. With that lack of response, that is when the company elected to move forward with treatment at Stanton as a show of good faith, knowing that we wouldn't meet the spring 2023 timeline.
Thank you. I don't have any other questions for you, Ms. Fetcher.
Any objection to Exhibit 9, the Senate Bill 72 document being admitted into evidence?
Staff objects on the basis of hearsay.
Objection, Your Honor. It's a government issued document. You're able to take administrative notice of it. I don't think its authenticity is in question.
It's not Senate Bill 72. It's
No,
not an order.
it's issued by the Delaware Health and Social Services Division of Public Health. It's a government document.
The witness has no knowledge of the document. It's not a statute. It's not a bill. It's not an order. It's not filed in a filing system.
On its face, it says it's issued by Delaware Department of Health and Social Services Office of Drinking Water. So, any objection from DPA?
No.
Okay, I'm going to admit it as Exhibit 9 as a government document. So that's Exhibit 9. Is there any cross?
No, before we adjourn, I want to make sure that the two exhibits that I had marked, PSC 1.1 and 4.2, are in, I'm sorry, 2.4 are admitted into evidence. I moved to have them marked, but I think Your Honor said that they were admitted. So I wanted to make sure that they're admitted.
1.1 is admitted into evidence as Exhibit 7, and 2.4 is already admitted into evidence as Exhibit 8.
Thank you, Your Honor.
Okay. Okay, so let's adjourn for lunch. And there's lunch in the PSC's cafeteria over here. It's 1:56, so let's take 45 minutes for lunch, which would be 2:45. And I just spoke with Gloria, and so we'll go until 5 o'clock today. So we have until 2:45. Please be here on time and we can get started. And if someone could get me a copy of the partial settlement agreement so that I can have it here as Exhibit 1, I would appreciate it. And so let's adjourn for lunch.
We're printing it. It's printing
Okay,
like this. So-
okay. I can wait until I actually get a good copy of it. I just thought you would be able to print it. But let's just be back here at 2:45.
I do.
Your Honor, may I approach the witness on the bench?
Yes.
Good afternoon, Mr. Murray.
Afternoon.
I just handed you a document. Do you know what that is?
I do. It is my testimony.
And you prepared that testimony, correct?
I did.
If I were to ask you all of the questions in that testimony today, would your answers be the same?
They would.
And do you have anything that you need to correct in that testimony?
I think it's all good.
Your Honor, at this point, I would like to move for admission of Mr. Murray's rebuttal testimony as Exhibit 10.
Any objections, staff?
No objection.
EPA?
No objections.
The testimony of Craig W. Murray, PE, is admitted into evidence as Exhibit 10.
Thank you, Your Honor. I don't have any other questions for Mr. Murray on direct.
Cross, staff?
Yes, Your Honor. May I pass out my handouts? Thank you.
Bless you.
You ready, Mr. Murray?
Yes.
Right. On page 4 of your rebuttal testimony, and I am looking at line 20, you state, I served as the project manager for the design and construction of the Stanton Water Treatment Plant PFAS project, correct?
That is correct.
And then on pages 4 to 5, so starting on 4 at line 21, in May of 2022, the design build team submitted a proposal in response to a request for proposal issued by Veolia Water Delaware. The project was awarded to Ronca in October 2022. And then, how do you say the name of the company?
It's Dewey,
Dewey.
like the decimal system.
I was thinking of the beach. Began work on the design in November of 2022. Is that correct?
That is correct.
And then on page 5, your rebuttal testimony, I think I'm looking at line 2 here. I personally oversaw all engineering phases of the CHA Dewey contract, including the proposal development, basis of design, detailed design, construction, and startup, correct?
That is correct.
And then also on page 5, I'm starting at line 11. Your testimony states, my professional and certified engineering seal is associated with the permitting of this project and is affixed to numerous drawings for the project, including those associated with the treatment process design, correct?
That is correct.
And then on page 4, at the first line, you state that the purpose and nature of your testimony is to explain how the Stanton Water Treatment Plant PFAS system design process and construction implementation was consistent with industry standards, timely, focused on maintaining affordability and customer rates, and included rigorous alternative analyses relevant to the unique demands of the Stanton Water Treatment Plant, correct?
That is correct.
Thank you. So you worked with the company that was awarded a contract by Veolia Water Delaware for the design and construction of the Stanton Water Treatment Plant, correct?
Correct.
And you oversaw the design and construction of the Stanton Water Treatment Plant, correct?
Correct.
And you and your employer were compensated by Veolia for that work?
We were?
And you filed rebuttal testimony in this case for Veolia Water Delaware to explain how the Stanton Water Treatment Plant PFAS system design, process, and construction implementation, which you oversaw and your company was hired to complete, was consistent with industry standards, timely focused on maintaining affordability and customer rates, and included rigorous alternative analyses relevant to the unique demands of the Stanton Water Treatment Plant. Is that correct?
Yes, we focused on making it as cost-effective as possible.
Thank you. And you received compensation from Veolia for preparing this rebuttal testimony, correct? To confirm your involvement with the Stanton Water Treatment Plant, Mr. Murray, you became involved during the design and construction, project proposal preparation, design and construction of the Stanton Water Treatment Plant, correct?
That is correct.
So you were not involved in discussions with or within Veolia Water Delaware in advance of its decision to issue a request for proposals for design and construction of the Stanton Water Treatment Plant, correct?
That is correct.
On page 4 of your rebuttal testimonies, starting at line 1, you state the purpose of your testimony is to respond to the testimony of PSC staff witnesses Ara Azad and Ava Azad and the Azad's recommended disallowance of the Stanton Water Treatment Plant capital expenditures incurred by Veolia Water Delaware. Is that correct?
That's correct.
So to summarize, the purpose of your testimony, your rebuttal testimony, is to respond to staff's expert recommendations in this rate proceeding to disallow recovery of capital expenditures incurred by Veolia Water Delaware for PFAS treatment and to disallow recovery of PFAS O&M expenses incurred after the test period, correct? On page 17 of your rebuttal testimony, starting on line 12, you say, as discussed more fully in the testimony of company witness Hatch, Ms. Ara Azad, and DPA witness Watkins recommended that the company's proposal to recover out-of-test period PFAS O&M costs should be rejected, correct?
That's the question, yes.
And you continue on pages 17 and 18 of your rebuttal to give your opinion on Ms. Ara Azad's and Mr. Watkins' recommendation regarding disallowance of test period PFAS O&M, correct?
Well, I'd like to go back and clarify you didn't read the full question. This response is primarily related to the second sentence of that question about, in my professional opinion, are these O&M costs necessary for it to operate?
And that's in response to Ms. Azad or Ara Azad and
That's correct.
Mr. Watkins, correct? Okay. On page 24 of your rebuttal testimony, looking at line 4 there,
I'm sorry, which line?
line 4,
Okay.
the question. Staff and DPA have asserted that the operations and maintenance costs for media changeouts are not known and measurable. Do you agree? And then you proceeded to provide an answer, correct?
That is correct.
Mr. Murray, are you an accountant?
I'm not.
Do you have an accounting degree or accounting certifications?
I do not.
Are you an expert in rate setting procedures for regulated utilities?
I'm not.
How many rate cases have you provided expert testimony on accounting issues in particular?
I have not testified before.
To confirm your involvement with the Stanton Water Treatment Plant. I'm sorry, I already asked those questions. Going back to page 24, where you stated that O&M costs for media changeouts are known and measurable, correct?
That's correct.
Then you say on page 24, the cost and replacement of the media must occur at regular intervals. Is that correct?
That's correct.
And then also on page 19 of your testimony, lines 15 and 16, you state company witness Fetcher states that the media changeout frequency is still unknown, correct?
That is correct.
So if you don't know how often you need to change out the media, then it is not possible to know how much media changeouts will cost in a given year, correct?
At a given time, that can be estimated and be known and measurable. That doesn't mean it's fixed.
But if you don't know how often you're going to have to change out the media, then you cannot know how much it's going to cost in a given year. If you change out the media one time, if you change out the media 2 times.
Yeah, we did, as Ms. Fesher mentioned, we did pilot studies to try and provide the best estimate as we could about the media frequency change out. Essentially, every chemical at the Veolia water treatment plant is considered known and measurable, but it varies over the course of the year. As more information is available, that frequency will be dialed in, and that frequency is completely dependent on what the influent water is coming into the treatment plant. But that doesn't mean it can't be known and measurable at a specific period of time.
Can you explain to me how something can be known and measurable and you can adequately quantify it if you don't know how often you're going to have to use it?
As an example, it's not directly related to this, but if I were to go buy a house 6 months from now, right now the interest rate is known and measurable, and I can determine what that house would cost. 6 months from now, that interest rate is going to be different. That doesn't make it any less known or measurable at this time. Extensive studies were done during the pilot treatment system to be able to provide the best case estimate, and the media price was obtained through competitive bidding to be able to get the best price available. So at any given time, we as engineers take the data we have, and that is the known part, and then we measure it and can provide a projection.
You're giving a projection, not a known number.
It's known at the time. At that time, if the media was going to be changed out 9 months from now, that was what the cost was going to be.
I guess my question is, how can it be known if you're making a projection? How can you be certain if you're making a projection?
Not sure certainty is the question. I mean,
if something is known, then you know what it's going to be. If it's known
moment.
and measurable, then you have an amount. It's a fixed number. In your mortgage example, you do not have a known. You do not know what that mortgage is going to be 6 months from now. You only have a projection for what is going to be 6 months from now based on the information you have now, but you don't know exactly what.
Correct, but at that time, you're deciding whether you think you're making projections as whether you can afford it down the road when you buy that house. But at that time, all of those numbers were known and measurable based on all the information that we had.
Can you give me a definition for known and measurable?
Known is that the media was going to have to be replaced, so we know that it is going to need to be replaced. And measurable was what would it cost based on the information we have. We can quantify that and put a dollar value to it. So at that moment, we knew it had to be replaced, and we knew what it was going to cost at that time.
In the future, will the PFAS O&M costs be costs that regularly occur for the remainder of the life of the treatment plant?
They will.
So they're going to be incurred in the normal course of business.
That is correct.
And they will not be expenses that are considered unusual or infrequent.
Overruled.
Can you repeat that question?
They will not be expenses that are infrequent or unusual, correct?
No, we know that we are going to have to replace the GAC at regular intervals. How the accounting is done within Veolia, I'm not sure.
Mr. Murray, page 14 of your rebuttal testimony presents the following question. That's at the top.
Hmm?
Do you agree with Ms. Ava Azad's conclusion that Veolia's decision to perform monthly PFAS testing goes threefold beyond the EPA's most stringent requirement and is not required by the state of Delaware and is therefore unnecessary and inappropriate, correct?
Your Honor, I'm going to object to this line of questioning based on Your Honor's order from yesterday afternoon, precluding that opinion from Ms. Avazad.
Your Honor has not made a ruling on whether that is specifically excluded. Staff maintains that that language is not precluded because it gives factual information. Just putting two pieces of facts together, not giving an opinion or a recommendation.
Objection sustained.
No further questions, Your Honor.
DPA,
Questions from the D.
redirect.
Thank you, Your Honor. Mr. Murray, in terms of the testimony that you prepared in this case, I think Ms. Workman asked you if you had given expert testimony from a rate-making perspective in the past. Do you recall that question?
I do.
Was the purpose of your testimony in this case to serve as a rate-making expert?
It was not.
In what capacity were you offering your expert opinion in this case?
Around the need and the cost effectiveness of the design and construction of the PFAS treatment facility.
And so when Ms. Workman was discussing the terms known and measurable with you, from what perspective were you testifying as to those terms?
As an engineer,
One moment, Your Honor. Nothing further.
Okay, thank you. Next witness.
The company is going to call Mr. James Cosgrove as its next witness, Your Honor.
Yeah.
Good afternoon, Mr. Murray. Mr. Cosgrove. Sorry. It's been a long day. Your Honor, may I approach? Mr. Cosgrove, do you recognize the document that I just handed to you?
Yes, I do. It's the dated November 25th.
Your rebuttal testimony, correct?
Yes, it is. Yes, it is.
And did you prepare that testimony in this case?
Yes, I did.
If I were to ask you all of the questions contained in that testimony again today, would your answers be the same as they were in that testimony?
It would be the same.
At this time, do you have any corrections to that testimony?
Yes, I have two. On page 5, line
3, there's a statement in parentheses that says PFOA plus PFAS, PFAS equals 70 PPT, and PFAS should have been PFOS.
You say that acronym one more time.
Sure, where it says PFAS, it should have been PFOS.
Thank you. And you mentioned you had another correction, I believe.
Yes, that is on page 24, line 3. Line 3 says, once the company understood the type of treatment needed and that 21, and then on the next line goes on to say large vessels would be required to hold the media. That should be 42 large vessels. It was 21 skids, 42 large vessels.
Thank you. Other than those two, are there any other corrections to your testimony?
No.
Your Honor, at this point, I would move for the admission of the rebuttal testimony of James Cosgrove as Exhibit 11.
Any objections, staff?
Staff objects on the grounds that Mr. Cosgrove's testimony gives legal opinions outside his area of expertise.
Okay. Where does he do that?
So looking at page 3, starting with line 11, it asks, what's the purpose and nature of your testimony? He says he's responding to Ava Azad and Ara Azad. And then he goes on to, in page 4, that first question, or I'm sorry, the second question, line 7, please generally describe your understanding of the health and safety standards, laws, regulations, policies, and guidelines in that section, which lasts 1, 2, 3, 4, 5, 6.5 pages. He gives his opinion on the applicability of various regulations. Your Honor, we had not planned to object to this. We had planned to handle this on cross-examination, but given your other rulings today, strictly limiting portions of testimony, we thought it would be best to address it before we got started. And then he's asked to give his opinion. I'm on page 10, question 13. He's asked to give his opinion about the timing based on the regulatory history. So he's asked to give an opinion based on regulations, which very much is interpreting the law. Page 12, he references Ava Azad's characterization of the state and federal regulations underpinning the company's obligation to treat PFAS. He is not qualified to give an opinion on that. Again, that's a legal assessment. Then on page 14, question or line 17, do you agree with Ava Azad's conclusion that the company's decision to perform monthly PFAS testing goes threefold beyond the EPA's most stringent requirement? Again, he's interpreting the law there and is not required by the state of Delaware and is therefore not appropriate. Again, that's giving a legal interpretation of whether something is or is not appropriate under the law. Line 18 on page 15, is it your opinion the company's decision to perform monthly PFAS sampling is supported by state and federal law? Again, asking for his interpretation of state and federal law. Question or line 20 on page 18. Is it your opinion the company appropriately assessed the regulatory timeline before moving forward? Again, it's asking him to interpret the regulatory timeline and how that is or was not appropriate at that time. That line of questioning is continued on line 16 of page 19, asking if they could have delayed. And in that response, he talks extensively about the rules and regulations when they were adopted. Line 21, line 13, his question, is it your opinion that the company adequately considered alternatives prior to constructing its PFAS treatment plant? Page 21, I apologize. And that, I'm starting at line 13, that question. I wouldn't object to that. Wouldn't object to the question on 23, which is it your opinion that the company reduced costs by the manner in which they contracted, designed, constructed, and pilot tested? That's very much within the realm of an engineer's expert opinion. I think you can speak to the question on 26. The question on 27, line 15, in your opinion, do witness Avazad and Arazad align with the state's determination to protect public health and public safety standards established by state and federal environmental agencies? Again, that's asking for him to say whether or not something is appropriate with regarding a state and federal agency. I wouldn't object to the question on line 11 on page 28. Or the question on page 29. Or the question on page 30. Or 31 or 32. So we're objecting to most of his testimony.
DPA?
We take no position.
Okay. Company?
Your Honor, Mr. Cosgrove is not testifying as a legal expert here. He's not offering a legal opinion. If you look at Mr. Cosgrove's CV, which is attached to as attachment 1 to his testimony, not only is he a licensed engineer, but he also has other background that gives him unique perspective on how water companies deal with regulations. He's on the board of directors of a water company. He's also served on the Clean Water Council and continues to serve on the Clean Water Council for the state of New Jersey. So he's not simply testifying as an expert engineer here. He's testifying as someone who has substantial experience operating a water company and serving as a board of directors of the water company, but also being in an environment for several decades where he's had the opportunity to interact with environmental regulations impacting water purveyors. I think that the characterization of some of the questions that counsel pointed out as interpreting statutes or legal opinions are simply not true. He's, to the questions that were asked of Ms. Fetcher earlier, he's providing his understanding of those regulations in the regulatory environment as they influenced a responsible water provider's obligation to provide safe, clean, and reliable service.
Staff?
And in doing so, he interprets the regulations. Like they said, he's not a legal expert. He does not have the qualifications to make the statements that he makes in these instances. And, it's...
Your Honor, what counsel is looking at is the questions. She's not really hasn't described the answers that are objectionable. And so I think that's the key distinction here is we've heard nothing from counsel as to why the answers that Mr. Cosgrove provides to those questions are interpreting the law.
I can go through all of the answers. I think the question...
I mean, Your Honor, this would have been appropriate for a pre-hearing motion.
I agree that it would have been appropriate for a pre-hearing motion. What I was trying to do with the company's pre-hearing motion was because Ara Azad is a CPA and a rate of return expert, a financial person. I was trying to keep her testimony within the financial realm. And Ava Azad is an environmental lawyer with an environmental education, and I was attempting to keep her testimony as a lawyer. And it's not easy to do in a utility case like this. And so, because things often merge involving laws and regulations, state and federal regulations. But what staff is bringing up is, is pertinent that, the testimony is replete with legal questions and answers. I mean, we can, is it possible that we could mark this for exhibit for identification purposes, and you conduct your direct examination and stay away from legal questions and stay within the engineering realm, and in light of the order that I issued yesterday, and also the objection that I just sustained as to the ongoing PFAS operating expenses, and Ava Azad's testimony. Is it possible for you to do that, and then you all try to work out this, these issues? I mean, since this hearing apparently is going to continue through Wednesday, I guess, Mr. Cosgrove, you're from Princeton, New Jersey?
Sam.
Yeah. So, I mean, we could always do as much as we can now and then do more by Zoom.
Unfortunately, Your Honor, Mr. Cosgrove is only available for today and tomorrow. The snowstorm adjournment has created some travel issues where he would be unavailable next week. So it was our hope to get him done today or tomorrow at the latest. And Your Honor, we're happy to stipulate that Mr. Cosgrove is not offering a legal opinion or attempting to interpret a statute. I mean,
well, that doesn't help staff very much. As you know, that only goes so far, because what happens then is that the company gets in all the evidence in, and you just say, well, we got all the evidence in, but he's not a lawyer. So, is it possible for Mr. Cosgrove to stay over and you all work this out late after the hearing, and we take him tomorrow on? I agree that this should have been brought up pre-hearing. I mean, I had given a pre-hearing motion deadline. I realized the company complied with it, but this is what we're facing now.
I understand that, Your Honor. Certainly we can attempt to work together with staff over, before tomorrow and attempt to limit this. As you may expect, there's probably going to be some disagreements that will still require Your Honor's involvement, but I think that would be a much easier solution than trying to kind of work through this on the spot here and potentially running into all the same issues. We have other witnesses who we're prepared to call at this moment, if that is what Your Honor.
I think that's the better way. And, with the hearing starting at 9:30 tomorrow, there's no reason why all of the attorneys and myself can't be here at 8:30. Gloria, can you be here at 8:30? No.
It's, I mean, frankly, it's very difficult with daycare drop off. Try, but
Okay, 9.
do my best, Your Honor. I mean, I will try and be here at 8:30. I'm just,
Maybe you could call in.
I'll be on the road by, I'll do my best, Your Honor. It's just, it's difficult.
You know, I try to accommodate everybody. Believe me, this is not easy, you know. It's just, I'm trying to get this done within 5 days, and this is moving slowly. I don't want everybody to listen to this because this is going to be, let's just start at 9 o'clock tomorrow, and, you know, staff and the company need to meet after today and try to work this out. I'm sure at least some of this can be worked out.
I agree, Your Honor.
Okay, so let's I'm gonna release Mr. Cosgrove and for now, and we'll have him testify tomorrow. I apologize. And let's have the company call its next witness.
Your Honor, we're going to go a little bit out of order here, but we're going to call Dane Watson, I'm sorry.
Just before we move on to Mr. Watson, do we still keep as Exhibit 11 marked for identification purposes, Mr. Cosgrove?
That's the,
I think so. And then if we,
I was going to mark that as identification purposes for the record, and then I had turned to staff, and then all that occurs, right?
so it's not being admitted at the.
It's not being admitted. Just so the record is as clear as it can be, and then we'll have as Exhibit 12 Mr. Watson's testimony.
I do.
Your Honor, may I approach?
Yes.
Mr. Watson, I've just handed you 2 documents. Can you tell me what they are?
Yes, the first one is my direct testimony in this proceeding. And the second one is my rebuttal testimony in this proceeding as well.
Thank you. And for both of those documents, did you prepare them?
I did.
And for both of those documents, if I were to ask you the same questions that are in those documents today, would your answers be the same?
They would.
Do you have any corrections to either of those documents?
I do not.
Thank you. Thank you. At this point in time, Your Honor, I would move for the admission of Mr. Watson's direct testimony as Exhibit 12.
Okay, and the rebuttal testimony is Exhibit 13.
Yes, Your Honor.
Okay. Staff, any objection?
Staff.
DPA.
No objection.
Okay. The direct testimony of Dane A. Watson, PE, CDP is admitted as Exhibit 12, and the rebuttal testimony of Dane Watson is admitted as Exhibit 13. Both exhibits are admitted into evidence.
I have nothing further for Mr. Watson on direct, Your Honor.
Cross staff.
Good afternoon, Mr. Watson.
Good afternoon.
Testified in your rebuttal that there is not a set required interval for conducting depreciation studies. Is that correct?
Could you tell me what line, page and line you're seeing that at?
Page 5, beginning on line 18.
Yes, I see it. To my knowledge, there's no prescribed time period in Delaware to do a depreciation study.
Yeah.
I'm sorry?
So my answer is yes, correct?
Well, would you repeat it then? Because I think it was a little too broad.
Testified in your rebuttal testimony that there is not a set required interval for conducting depreciation studies. Is that correct?
In Delaware.
So the company in this matter didn't have to do this depreciation study at this time, correct?
To the best of my knowledge, there was no prescribed period that they had to, although from it was a good decision.
The cost of the company spent to complete the depreciation study is passed on to the company's ratepayers, their rates, correct?
I'm not involved in that piece. I can't respond to that question.
In your rebuttal testimony, you testified that the industry standard for updating depreciation studies is 3 to 5 years, correct?
Yes.
In connection with that testimony, did you consider the frequency with which publicly regulated utilities in the state of Delaware historically update depreciation studies?
I don't know that I would consider a different time period for different states. That's a the general framework for utilities across North America.
In that general framework, industry standard, as you testified to, did you look at historical data for publicly regulated utilities in Delaware coming up with that?
No, it's an industry standard. I did not go back and look at other utilities in Delaware.
You testified that prior to this case, the company's last depreciation study was done in 2019 in PSC docket number 19-0615. Is that correct?
And where are you finding that, please? Second.
I believe that's in your direct testimony. If you turn to your rebuttal testimony, page 3, lines 4 through 10. Also, if you look at your direct testimony, page 1, line 6.
Yes, that is correct. What I said.
Do you know when, prior to the 2019 case we just discussed, when the last depreciation study was done by the company?
I don't.
So you do not know if the company has historically updated its depreciation studies every 3 to 5 years, as you testified as industry standard, correct?
No, I do not know that fact.
If the company had decided as part of this current case to hold off on performing a new depreciation study, do you know how much it would have saved ratepayers?
Zero.
So,
Depreciation is recovered from customers. If you defer creating a correct depreciation rate, then it falls on future customers to pay the cost that current customers should have paid. So overall, the cost to customers, absent time value of money, would be the same. It's just you're shifting some of the costs that should be paid today to tomorrow. So from that perspective, customers will pay the cost of the assets invested in them by the company. It's just a matter of the timing. And do you do the timing right so that customers today pay their fair share, or do you not, and customers 5 and 10 years from now will pay that?
customers would be paying more.
Not if the study is not completed, not if the study is not authorized.
Your testimony didn't consider whether the application of the proposed depreciation rates would result in just and reasonable rates to rate. Correct?
And would you show me where that is?
Said your testimony didn't consider that.
Oh, I'm sorry. I would consider just and reasonable depreciation expense so that all generations of customer will pay for their same share as they should of the assets. Beyond that, that's not part of the scope of my testimony.
EPA?
Briefly, Mr. Watson, towards the end of your rebuttal testimony, you're asked whether or not you agree with Mr. Watkins' computation of depreciation expense, correct? Page 7.
Yes, I recall that. Can you tell me the page?
It's on page 7, the last page there. And you start off your testimony by saying, no, while he accepted the results of Veolia's updated depreciation study, DPA witness Watkins does not include one component of the proposed rates that I sponsored. And he failed to include an amount for what I termed the general plant true-up, correct?
Yes.
Okay. But at the same time, you're in general agreement with Mr. Watkins' computation of depreciation expenses in this matter, correct?
I believe he had the same rates as we did in the computation, from what I understand, in the calculation of the rates. But the only thing he left out, the only thing that was different was that he didn't include the true-up, which would reduce the rate slightly.
But in the end, he accepted the results of Veolia's updated.
Yes, that's my understanding.
And the exclusion reduced the depreciation expense, correct?
I'm sorry.
So, and he did not include this reduction in the proposed depreciation expense?
Yes, that's dealing with the a true-up provision of the general plan amortization. By including that, it would reduce by the $2,000, I believe it is $2,600, the total depreciation expense the company should be recovering each year.
Thank you. No further questions.
Redirect?
Thank you, Your Honor. Mr. Watson, do you recall a moment ago testifying concerning the industry standard for conducting a depreciation study?
Yes.
And I believe you said it was 3 to 5 years, correct?
Correct.
Can you explain why that is the period?
Yes. The reason that industry professionals believe that that's an appropriate time period is that the conditions change in companies over time. For example, in Veolia, Delaware, the amount of removal costs that they spend every year and on a 5-year basis has increased materially since the last depreciation study. So capturing that from a period of 3 to 5 years will allow you to reset to where you're recovering the right amount of removal costs based on the 5-year historical average. If you wait 10 or 15 years, it will be probably dramatically out of sync, and it will cause a very material issue. So that's just one of the reasons a company would do it every 3 to 5 years. I pointed out a couple of others in my rebuttal testimony in the mains account, where the tremendous amount of investment over the last 5 years, and as a result of the different factors that go into the study, the rate changed some, not a lot, but it adjusted for the factors and the things that we see differently now than we did 5 years ago. So sometimes companies will do it sooner if they have more material changes in their operation, but typically a 3 to 5 year period will be soon enough to be able to reflect those changes as needed, but long enough so you can see the changes.
And can you provide any examples of depreciation rates going up and down?
Absolutely. In my rebuttal testimony, as I started to mention, I believe it is on page, it's not a long testimony, I should be able to find it quickly. Starting on page 4 of my rebuttal testimony. This is just one of the examples. Just to give you an overview, there were 6 accounts, I believe, where the life increased in my study compared to, 6 where it decreased in my study, and a few that increased. So we made minor changes in several of the accounts when we saw more recent history and the projection of what both the analytics were telling us and what the operations of the company were doing. So both of those, and there were only a couple that adjusted more than a year or two that were of a material nature. But there are 3 components that make up a depreciation rate. One is the amount of investment, and the addition to investment was very large for Veolia in the last 5 years. One is the reserve position, meaning how much reserve have you recovered compared to how much you should have recovered. And the third one is how much time left do you have in order to recover the cost of the assets. So all 3 of those were changing. And they, in this particular case for 343, which is transmission and distribution mains, it's nearly 40% of the total assets. And they've had $27 million over the last 5 years added. And the rate was 1%. A 1% rate would effectively mean that it has a 100-year life. And the projection of the life of the mains is less than, it is, I believe, 80 or 85. I'd have to look back. So the rate, it was set a little lower than what it should have been or needed to be in order to recover the investment from the older assets and the 27 million new that put in. If it's an 85-year life, the rate changed to 1.24%. So not just 24 basis points, but it reflected the fact that we're resetting it back to the life expectation and the recovery of those dollars over that actual life instead of some longer period of time. So there are a number of accounts that see that, not to that degree. And I mentioned the net salvage was one of the other factors that created that issue. There was, I think, $166,000 more that had been actually spent by the company in removal cost on the 5-year average now than it was back in 2019. And so they should be able to recover that actual spend, annual actual spend going forward instead of something that was set 5 years ago.
Thank you, Mr. Watson. I have one more question, or 2 more questions, I guess. Assuming all else is equal, if the lives of an asset increase, is it true that the lives of an asset increase, is it true that the rate decreases? Depreciation rate decreases?
Yes, because that governs the number of years you actually have to recover the asset cost. So longer lives, more years, lower depreciation expense in any year.
Is the converse also true?
It is.
Thank you. I don't have any other questions.
Staff,
Nothing wrong.
EPA? No, Your Honor. Okay, thank you.
Thank you.
Your Honor, may we take a short break? We need to evaluate our witness order.
Yes.
Thank you.
Okay, we're back on the record.
Thank you, Your Honor. The company would like to call Mary Ann Hatch as the next witness.
I do.
May I approach, Your Honor?
Yes.
Good afternoon, Ms. Hatch.
Good afternoon.
I just handed you 2 documents. Can you please tell me what they are?
Yes, the first one is the direct testimony of James C. Cagle on behalf of Veolia Water Delaware, and that was filed on January 2025. The other document is the rebuttal testimony of myself, Mary Ann Hatch, on behalf of the company, and that was filed in November of 2025.
Thank you. And let's start with Mr. Cagle's testimony first. You are adopting that testimony today for the purposes of this proceeding, correct?
Correct.
Okay. And if I were to review the questions in that testimony with you, would your answers be the same as Mr. Cagle's?
Yes.
Okay. Do you have any corrections to that testimony today?
Not to Mr. Cagle's.
Thank you, Your Honor. At this point, I would move for the admission of Mr. Cagle's testimony as exhibit number 14.
Any objections, staff?
No objection.
DPA?
No objection.
The direct testimony of James C. Cagle is admitted as into evidence as exhibit number 14.
Thank you, Your Honor. Ms. Hatch, with respect to your rebuttal testimony, did you prepare that testimony?
I did.
And if I were to ask you the questions contained in that rebuttal testimony today, would your answers be the same?
Yes, but for one correction.
Can you tell us what that is, please?
Yes, looking at page 22, when you're looking at the paragraph lines 10 through 16, what it currently says is, while both cases resulted in settlement, it appears that in written testimony, witness Azad apparently did not take issue with these investments. I would like to correct that statement to say, while both cases resulted in settlement, it appears that staff and witness Azad in the Tidewater case apparently did not take issue with these investments.
Thank you. Other than that, any corrections?
No.
Your Honor, at this point, I would move for the admission of Ms. Hatch's rebuttal testimony into evidence as exhibit 15.
Staff, any objection?
Yes, we do have an objection based on new information that was provided in rebuttal testimony. In the direct testimony, there was no reference to a surcharge or a rate rider, but in Ms. Hatch's rebuttal testimony, she brings up this new mechanism for PFAS O&M expenses that occurred out of the test period. And so we would object to only that portion of her testimony.
Which page are you referring to?
So I have written down page 26, starting at line 10. It says, please explain in greater detail the company's revised surcharge mechanism. The surcharge is referenced several times throughout, but that's the main place it starts. And then that goes through page 27, line 28, and then page 29, lines 1 through 10. And those are strictly the portions that discuss this surcharge mechanism that wasn't brought up until the rebuttal testimony.
Your Honor, may I respond?
Yes.
Thank you, Your Honor. Ms. Hatch's testimony concerning the surcharge mechanism for PFAS O&M was made in direct response to the direct testimony provided by staff and the DPA. So it was responding to that. And to the extent that staff and or DPA wish to have a chance to respond, this testimony was filed on November 4th. They had ample opportunity to request consent to file a rebuttal, to seek leave to file a rebuttal, and quite frankly, the company would have consented to that. And consistent with the other issue here today, if staff sought to exclude this testimony, they should have filed a pre-hearing motion. I don't think there's any basis to exclude this testimony simply because they had the opportunity to respond but chose not to.
Your Honor, staff never had the opportunity to respond. He's asking staff to go above and beyond what is required of staff in this case. And frankly, not all lawyers get paid by the hour. And so we are unable.
Objection, Your Honor. Objection.
Abstain.
Honor, I'd like to, I agree with staff's position on this matter as well, Honor.
I saw this when I read Ms. Hatch's testimony. What, just for the record, what exactly does this surcharge mechanism do? Just Reader's Digest version.
Sure, it is essentially a disk-like mechanism to recover the PFAS O&M costs in as close to a real-time incurrence of those costs as possible. So the company, the media change-out costs. So the company would essentially pay for those costs and then submit periodic filings where staff and DPA can review those costs so that there is a more verifiable mechanism for the company to recover those costs.
Well, I think staff and the DPA are correct that this is something that should not have been brought up on rebuttal, because rebuttal is, just as the name states, it's rebutting what's in the testimony that staff and the DPA filed, and therefore I am going to strike the testimony that was cited by staff.
And that, can I just confirm, that begins on page 26, line 10, and goes to 27, line 20. Kate, tell me if I'm wrong. 27, line 28.
If you look at the exhibit log that we submitted to the hearing examiner, the lines are spelled out on 25, where we have Mark, and then page 26, line 10.
It starts on page 25, line 10.
26, line
26.
10. Is it 25? Oh, I apologize, Your Honor. It's 25, line 10. And then we have through page 27, line 28. And then also page 29, lines 1 through 10.
Okay, so with that being said, with that being done, will staff agree to the testimony being admitted into evidence?
Yes, Your Honor.
Okay, DPA? Okay. With that change to the testimony, the rebuttal testimony of Marianne Hatch is admitted into evidence as Exhibit 15.
I have no further direct for Ms. Hatch.
Cross staff.
May I pass out my documents, Your Honor?
Sure, I was
Thank you.
expecting them.
Yep.
You ready, Ms. Hatch, or do you want a minute?
We can go ahead and start.
Okay. On page 3 of your rebuttal testimony, at the very top there, you say that staff and the DPA's recommendation to reject the company's out-of-test period PFAS-related O&M expenses, and you include a parenthetical which says without a proposed alternative. Is that correct?
That is correct.
Do you believe it is the responsibility of staff and the DPA to conduct alternative analyses when they determine something should not be disallowed?
Objection to form. Would not for sure the phrase alternative analyses.
Overruled.
I can always repeat the question.
Please repeat the question.
Just ask. I'll be happy to.
Thank you.
Do you believe it is the responsibility of staff and the DPA to conduct alternative analysis when they determine something should be disallowed, or give an alternative proposal when they determine something should be disallowed?
Well, I can't speak for what DPA's duties are because I think that those duties are focused on the ratepayers. I believe that commission staff, based on my understanding and at one time being a staff witness at the Federal Energy Regulatory Commission, I believe that there is a responsibility to balance both the interests of the customer and the company.
So in a rate case, isn't it true that the company has the burden of proof?
Objection calls for a legal opinion.
Sustain.
You stated at page 6, lines 26 to 27, that the company's PFAS O&M costs are now lower than originally projected. Is that correct?
That is correct.
And who made those original projections?
I don't know who made the original projections.
Let me rephrase. Was it the company who made those original projections?
Based on the testimonies of Mr. Cagle and Ms. Fesher, correct?
Are you familiar with the testimony of company witnesses Murray and Cosgrove?
Yes.
Do you agree that both Murray and Cosgrove characterize out-of-test period PFAS O&M as known and measurable in their testimonies?
I believe they do.
Do you agree with Mr. Murray and Mr. Cosgrove that the PFAS O&M costs are known and measurable?
Well, I think that after just listening to Mr. Murray's testimony, I think people look at that from different perspectives. And Mr. Murray and perhaps Mr. Cosgrove may have answered that from the perspective of an engineer.
Do you agree with them or not?
Well, I'm not an engineer, so I don't know if I agree with their interpretation of what known and measurable is.
I'm not asking you as an engineer. I'm asking, they said it's known and measurable. Based on your understanding of known and measurable, do you agree that those costs are known and measurable?
Objection lacks foundation.
Overruled. You may answer.
I believe that we discussed the known and measurable nature of certain costs in my testimony. Known and measurable can happen at a point in time, and it does have certain nuances when you're talking about it in the rate-making context.
Ms. Hatch, I'm asking if you believe the PFAS O&M costs that we've been referencing throughout the proceeding are known and measurable. Murray and Cosgrove said yes. What do you say? I'm looking for a yes or no. You give me a yes or no and then quantify it, that's perfectly acceptable.
Subject to checking my testimony, yes.
And for the remainder of the life of the Stanton Water Treatment Plant, the PFAS O&M costs are going to be regularly occurring. Is that correct?
Yes, once we get into normal operations. And I would say that there is somewhat of a distinction there, as detailed in the testimony of witness Fesher. The plant has not even been in operation for a complete year. So when you listen to the testimony of witness Fesher and Mr. Cosgrove and Mr. Murray, they start talking about the science behind these treatment vessels and the natural nature of some of these contaminants. And a lot of this, the change out frequency will depend on what you learn as that plant goes into real-time service over time. So we don't even have a full year's worth of operations for this plant. And so when you look at the testimony of Ms. Fesher, she makes it clear that we have not done the change outs yet. We are continuing to learn about this plant in real time, and we have not yet incurred these PFAS costs, but we are learning over time. And so I think one of the distinctions here is that we know that these costs are coming. They're going to be significant for the company. Right now, we're still in learning phase. We still don't have a full year of data, but once we have the learnings, these are going to become a recurring part of the expenses for this plant.
So if that expense, the PFAS O&M expense, is a recurring expense, then would you consider that expense unusual or infrequent?
And that's the distinction I was just trying to make is once it goes into service and once it becomes a normal part of operations, then I would tend to agree with you. But right now, I would argue that we're kind of in that phase where we don't have a full year of operations yet, and we haven't quite done that treatment, the media change out yet. So we're in that interesting space of time where we're still starting up that plant, we're getting the data, and then as time goes on, those are going to become regularly occurring expenses.
Your rebuttal testimony on pages 22 and 23. I'm looking at the question that starts page 22, line 17. You state that you strongly disagree with the assertion that the company failed to conduct cost benefit and other analyses in the planning and decision making of the Stanton Water Treatment Plant PFAS plant. Is that correct?
Correct?
And on page 23, on line 1, you state that the company has a comprehensive internal capital governance process, correct?
Yes.
Does that process include cost benefit analyses?
It depends on the situation. When you look at the testimony of Ms. Gayla Fetcher, the issue is whether or not the initial alternatives are even feasible from the get-go. And from the company's perspective, if an alternative is not feasible, why would you spend the time and money to do a cost-benefit analysis? From an engineering perspective, it would make no sense. And if we're interested in balancing the cost for customers, why would we expend money studying a cost-benefit analysis for something that professional engineers have already deemed infeasible?
Are you familiar with staff data request 1.1 and 2.4?
Did you provide those in the handouts?
Yes, they should be hidden in there somewhere. Can anyone confirm that those are in the handouts?
It's Exhibit 7 and Exhibit 8.
Would anybody be able to give Ms. Hatch a copy of 1.1 and 2.4?
Bear with me.
I have extra.
I don't think so. My apologies. These are admitted as exhibits
7.
7 and 8. 1.1 is exhibit 7 and 4.1 is exhibit 8. In 1.1, staff requested alternatives that the company considered. Well, staff requested the alternatives the company considered to the Stanton Water Treatment Plant upgrades, correct?
Can you tell me which specific question, which part of this question you're referring to?
Yes, I believe it is the first portion. PSC 1.1A. Oh, I'm sorry, B.
Okay.
So in that section, does staff request alternatives to the Stanton Water Treatment Plant upgrades?
So part A, the question is whether or not staff asked please describe Veolia's process for evaluating available alternatives for compliance with U.S. EPA PFAS regulations?
Yes, I'm sorry, I meant B.
Okay, B. And that question states, please provide a list and description of each option Veolia considered in identifying and assessing viable options for addressing PFAS regulation requirements.
The reporter has a better shot.
Yeah, sorry about
pinning
that.
down what you're saying.
And then staff also requested a description and supporting documents of the cost benefit analyses conducted by the company, and that is part D. Is that correct?
Correct.
And then turning to 2.4. That request asked for confirmation that no documents of cost benefit analysis were provided to staff, correct?
Can you repeat the question?
Yes. In 2.4, staff asked for confirmation that no documents of cost benefit analyses were provided previously. Correct?
That is correct. And I would add that that question relates to PSC 1.1, which we already discussed. And in reviewing 1.1 Part B, I believe there was one clarifying point in there. Question B asked for the description of options that Veolia considered in identifying and assessing viable options. There were no viable options.
And then PSC 2.4, in the second paragraph, that last sentence, it asks the company, please confirm that no such documentation exists, or if it was omitted by error, please provide it in response. And that document is cost benefit analyses or related documentation such as expert reports, engineering analyses, accounting considerations, and applicable meeting minutes. Is that correct?
That is correct, and that was the response because the original request in 1.1b asked for analyses on viable options. As discussed by company witness Fescher, none of the other alternatives out there in space were even viable from an engineering perspective.
Would you agree or disagree that the parties in reviewing Veolia's application in any proceeding or any rate case really rely extensively on the responses to discovery questions that they ask the company?
I would tend to agree with that.
Would you agree that it's important for the company's answers for the company to answer completely the questions and then try to assist to the extent reasonable in the discovery process?
We answered the questions as written.
Would you agree that it's important to consider cost? Would you agree that it's important to consider alternatives to proposed projects that may achieve the same benefits as the proposed project at a lower cost?
Can you restate the question?
You want the question read back?
I'm trying to restate it rather than just read it back again.
I just need to hear it again.
Oh, okay. Would you agree that it is important to consider alternatives to proposed projects that may achieve the same benefits as the proposed project at a lower cost?
Well, I think that depends. Perhaps if you were comparing two things that did have similar benefits, then perhaps you would look into that. But as already discussed by company witness Fesher, the other alternatives were not feasible.
Do you know any of the specifics of what the company included in its revenue requirement in this case?
I'm not sure what you mean by specifics.
Just specific numbers, schedules, and such.
Not off the top of my head, no.
Are you aware that in the company's application, Veolia asked for a $15.9 million rate increase? And based on Veolia's 6/30/2025 work papers, the aggregate of the adjusted test period expenses in the 21 categories included in Veolia's application, when compared to the actual data for the test period, were overstated by more than 5.3 million.
Without seeing the numbers, I can't answer that question.
Okay. Your Honor, may I approach the witness?
Yes.
Yeah, I'm sorry, Kate, what are we referring to?
I apologize. We are referring to Ara Azad's direct testimony,
Which one?
the
Revenue
not,
or?
the not cost of capital one, the revenue requirement.
Kate, can you repeat the question, please?
Yes, I have not stated the question yet. I was just waiting for Mr. Simon to get.
What, do you know the page?
Yes, I do. Page 16, line 16. Page 16, line 16. So in there, Ara Azad testified that when compared to the actual test period results, Veolia overestimated the expenses by approximately 6.1 million in the top 5 categories of expenses, which are chemicals, outside services, payroll, rents, and M&S. When developing the revenue increase, the company is requesting in its application. So that's her statement. Then when taken for all 21 categories of costs, Veolia overstated operations and maintenance expenses by 33.32%. That is Ms. Azad's testimony that the actual expenses exceeded the projected expenses. Is that correct? I'm just asking if it is her testimony that the actual expenses were less than the projected expenses.
The actual expenses were less than the projected expenses.
Thank you. So at the end of the test period, when actual accounting information was available, Veolia maintained its position at a requested 15.9 million increase, correct?
We revised the position in our rebuttal testimony filed on November 4th.
And that was provided in the rebuttal testimony, not before then, correct? On page 18 of your rebuttal testimony, lines 9 through 11, you state the company's intention was, is, and always will be to flow any funds obtained from alternative sources of PFAS funding dollar for dollar to customers, correct?
That is correct.
In Veolia's original request at $15.9 million for the rate increase for a test period that ended in June was not modified until the company's rebuttal testimony in November, correct?
The company's revenue requirement position did not change until rebuttal testimony filed November 4th.
Thank you. On page 7 of your rebuttal testimony, lines 7 through 11, you highlight your understanding of Veolia's responsibility of financial stewardship and protecting customers' affordability needs, correct?
Correct. I state that drinking water purveyors have 2 critical obligations: adhering to public safety determinations by relevant Yep. My apologies. We have 2 critical obligations: adhering to public safety determinations by relevant jurisdictional agencies and financial stewardship.
In particular, You recognize a utility's obligation to practice sound financial stewardship to protect affordability for customers, right?
Correct. We have to balance that with the realities of public safety determinations.
Did the company conduct an affordability study in consideration of the company's financial stewardship obligations when considering how to comply with PFAS regulations?
Not to my awareness, nor am I aware of any such requirement.
Do you believe that the failure to document any cost considerations prior to committing to the $40 million upgrades to the Stanton Water Treatment Plant to be consistent with meeting obligations of financial stewardship grounded in protecting customer affordability needs?
Can you repeat the question?
Yes, do you believe that the failure to document any cost considerations prior to committing to the $40 million upgrades to the Stanton Water Treatment Plant to be consistent with meeting obligations of financial stewardship grounded in protecting customer affordability needs?
I'm afraid I can't respond to that question as posed because that would be admitting some sort of a failure, which I do not believe there was any. As discussed by company witness Fesher over and over again, the company determined that the alternatives out there in space were simply infeasible. And so, as a company, if we are to balance affordability for customers, why would we spend the time and hundreds of thousands of dollars doing cost benefit analyses on potential alternatives that are, from an engineering perspective, simply not feasible?
So your answer to that is no.
Objection, mischaracterizing the witness's testimony.
Sustain.
Ms. Hatch, I'm asking a yes or no question. Do you believe that the failure to document any cost considerations prior to committing to the $40 million upgrades to the plant that we've been discussing to be consistent with meeting the obligations of financial stewardship grounded in protecting customer affordability needs? So, Your Honor, she refused to answer the question. She said, I cannot answer the question. I'm simply asking yes or no. Is it consistent?
Objection. If the witness has stated she can't answer the question, yes or no, Your Honor, she provided an answer to the question, and now it's simply being re-asked because the answer was not one that counsel liked.
Overruled. Please answer the question.
I do not agree with assertion that there was any failure.
Your Honor, that still does not answer the question.
Okay.
We would accept an I don't know. I would accept that.
I thought her first answer was okay, but maybe rephrase it.
So you have stated that the company has a responsibility to protect customer affordability needs. However, the company failed to produce any documentation of cost considerations prior to committing to the $40 million upgrades to the Stanton Water Treatment Plant. Do you believe that those two ideas are consistent with each other?
In this instance, yes. Why would the company spend hundreds of thousands of dollars on cost benefit studies when, again, professional engineering judgment has already indicated that those potential alternatives are infeasible?
Attaching your rebuttal testimony, page 7, lines 11 to 14. You say, as provided in detail in company witnesses Cosgrove, Murray, and Fetcher's rebuttal testimony, since at least 2015, Delaware has made regulatory and policy changes that make clear its intent to advance public health protections related to PFAS compounds in the environment, including in drink. I apologize. Regulatory and policy changes that make clear its intent to advance public health protections related to PFAS compounds in the environment, including in drinking water, correct? Just that is your testimony on page 7, lines 11 to 14.
Correct.
So in your opinion, Veolia appropriately deems Mr. Cosgrove, Mr. Murray, and Ms. Fetcher reliable authorities for interpreting current and forecasted regulations.
Can you repeat that question again?
Yes. In your opinion, Veolia appropriately deems Mr. Cosgrove, Mr. Murray, and Ms. Fetcher reliable authorities for interpreting current and forecasted regulation.
Objection to the use of the term interpreting.
Your Honor, that's what their testimonies do, and that's one of the things we're fighting about, particularly in Mr. Cosgrove's.
Objection, she's now just mischaracterized 3 of the witnesses' testimonies.
Sustain, rephrase it, please.
So in your opinion, Veolia appropriately deems Mr. Cosgrove, Mr. Murray, and Ms. Fetcher reliable authorities to discuss current and forecasted regulations.
Yes, they're very smart people. They are engineers. They work around these issues on a regular basis, and they figure out how to solve a lot of these issues that are raised by regulations. So they understand them.
So in your professional opinion, Veolia's reliance on the opinions of engineering professionals to discuss regulatory standards that were in place or were anticipated by the company since 2015 were appropriate.
Objection, in what context were they appropriate?
In the context of providing testimony for the company in this proceeding.
Sustain, I think you need to rephrase it. There were 2 parts to the question. Maybe just combine them.
Do you believe it is good business judgment for an organization to base decisions regarding regulatory requirements on the opinions of engineers?
I think that as a company, we're a team, and of course, we rely on our engineers for their sound engineering judgment and understanding how to address some of the challenges raised by regulations. And it is also part of their job to figure out how to solve these problems in a timely fashion. So they do need to keep their ear to the ground and understand what is happening in the general context. For example, if you were to talk to witness Fesher or Mr. Murray, you have to have an understanding of what's coming down the line in the regulatory environment so that you can appropriately plan for a major capital project like the Stanton Water Treatment Plant.
So your rebuttal, page 8, lines 20 to 21. It states that the costs that the company incurred with respect to its investment in the Stanton Water Treatment Plant were made by the company on an informed basis. And then continuing on lines 23 and onto page 9, line 1 through 4. Indeed, as set forth in the rebuttal testimony of company witnesses Murray, Cosgrove, and Fetcher, the company's decision to design and build the Stanton Water Treatment Plant to treat for PFAS at the time it did was necessary to provide safe drinking water in conformance with applicable and to be applicable regulations and standards, correct?
That is what my testimony states.
So, based on your testimony, Veolia based decisions on the regulatory interpretations made by engineering experts to determine when to implement or when to design and build the Stanton Water Treatment Plant.
That is not what my testimony says. That's a paraphrasing.
Well, your testimony refers to the witnesses, the engineers, and their assessments and interpretations of the timeline necessary to comply with potential regulations. So did Veolia base its decisions on building, making these upgrades to the PFAS treatment plant based on regulatory decisions made by engineers?
I don't know because I was not there at that time.
Ms. Hatch, in your rebuttal testimony, page 10, lines 6 through 7, you state, in the prior base rate proceeding docket number 23-0598, the case was not filed on the premise of recovering out of test period costs. Is that correct?
That is correct.
Before you, you should have a copy of James Cagle's testimony from docket number 23-0598.
Yes.
Please refer to page 7. We're looking specifically at lines 8 to 10, where the company, now in those lines 8 to 10, page 7 of Mr. Cagle's testimony in docket 23-0598, he said that the proposed mechanism would include a surcharge, which will accumulate as a regulatory liability from the time of its implementation until the company's next rate case filing. And that surcharge was referring to charges that were not in the test period, correct?
Those surcharges were related to the upcoming capital investment costs associated with the Stanton treatment plant. So if you were to look at page 6 of that same testimony, lines 16 through 20, Mr. Cagle's testimony stated that at that time, current estimates of the project indicate plant and service will increase by approximately $45 million to $50 million. Additionally, related operation and maintenance costs for the treatment media are currently estimated to be $6 million annually, and depreciation expense will also increase significantly. His testimony also goes on to say that the proposed mechanism has two objectives. Number one was to reduce rate shock, and the second one was to reduce overall cost to customers.
And that mechanism that he proposed would have resulted in, had it been approved, would have resulted in the company recovering costs that were out of the test period, correct?
They were significant investment costs, and yes, the purpose was to defray the costs in the future.
But they were out of the test period, correct?
Correct.
I have no further questions for Ms. Hatch.
DPA,
DPA doesn't have any questions.
redirect.
Thank you, Your Honor. Ms. Hatch, can I refer you back to Exhibit 7, please, which is PSC 1.1?
Yes.
I'm specifically referring to PSC 1.1 subsection B. Please provide a list and description of each option Veolia considered in identifying and assessing viable options for addressing PFAS regulation requirements. Do you see that?
I do.
Ms. Hatch, you were present for the testimony of Ms. Fetcher, correct?
I was.
And you also have reviewed her rebuttal testimony, correct?
I have.
Does Ms. Fetcher provide a list of and description of each option Veolia considered in identifying and assessing viable options for addressing PFAS regulation requirements?
Objection, Your Honor. This is not within the scope of our cross.
Your Honor, she asked about PSC 1.1, specifically subsection B.
Overruled.
Can you repeat the question?
Yes. Can you read back the question, please? I'm so sorry.
Yes, Ms. Fescher's testimony does include a list of options or alternatives that were deemed infeasible.
Thank you. Do you recall speaking with Ms. Workman where she cited your testimony concerning the two critical obligations of water providers?
I do.
And she focused on one of the critical obligations you identified, which was financial stewardship. Do you remember the other critical obligation?
Yes, it's, let me look at my testimony really quick. It has to do with adhering to public safety determinations by relevant jurisdictional agencies.
Can those two critical obligations be considered in a vacuum from one another?
No.
With respect to the Stanton water treatment plant, did the company rely on engineering judgment and performing an alternatives analysis?
Yes.
Did the company rely on engineering judgment in determining how to effectively treat for PFAS?
Yes.
Did the company rely on engineering judgment as part of a viability determination for other PFAS treatment options?
That is my understanding, yes.
You were present for the testimony of Craig Murray earlier today, correct?
I was.
Do you recall his testimony that from an engineering perspective, PFAS media changeout costs are known and measurable?
I do recall.
And those media changeout costs are a significant part of the company's request in this case, correct?
They are.
Do you recall how much or what percentage they are?
Yeah, so in my rebuttal testimony, when I compare the PFAS O&M costs that the company is facing related to these media changeouts, it's roughly 7.5% of the total revenue requirement that we asked for in this case. And so to put that into perspective, if you were to take out those O&M costs and only give the company the expenses that we currently have in the line items, that would mean that we know as a company we're going to have to incur another $3.5 million of O&M expenses to maintain plant operations, to make sure that we are maintaining the safety of our customers. And we know we're going to have those expenses. Now, the issue is if we don't get recovery of that, these costs are so significant that it would eat up roughly 20% of our O&M budget that's already there. So it's kind of like saying, hey, you make $100,000 a year, but you now need to find an extra $20,000 somewhere else to pay for these expenses that you know are coming. And you know that so that's part of it. The other part is Gila Fetcher's testimony alludes to, the company has locked in the pricing with contracts. So these are expenses that we know are coming. We know that we're going to have to spend this money to maintain the public health, and it's going to be an extraordinary expense for the company.
Absent some mechanism to deal with recovery of those costs, would the company need to file a rate case earlier than it otherwise would?
Yes.
Just a moment, Your Honor. I think we're almost done. Ms. Hatch, do you recall Ms. Workman's questions to you concerning the company's reliance on the opinions of Mr. Murray, Mr. Cosgrove, and Ms. Fetcher?
Yes.
Do you recall when Mr. Murray, Ms. Fetcher, and Ms. Cosgrove issued their testimonies in this case?
I do.
When was that?
This afternoon, this morning.
Do you remember when the rebuttal testimonies were filed?
Yes, apologies. Thank you for the clarification. The rebuttals were filed on November 4th, 2025.
And do you recall when the decision was made to proceed with the construction of the Stanton Water Treatment Plant, PFAS engineering component?
Subject to checking testimony of Ms. Fetcher, I believe that construction began in 2022.
All right, thank you. I don't have any other questions for you.
Thank you.
Staff?
Very quickly, in talking with Mr. Simon, you referred to the testimony of Ms. Fetcher, particularly that table where she laid out the other alternatives considered by the company for complying with PFAS regulations. Now, isn't it true that Fetcher's testimony came significantly after the responses to PSC 1.1 and PSC 2.4.
The rebuttal testimony did come after those responses.
And the rebuttal testimony, of course, came after the direct testimony of Ara Azad. Is that correct?
Correct?
So the company did not provide that comprehensive list of alternatives considered until rebuttal testimony after staff had submitted their direct testimony criticizing it.
Again, I would refer you back to PSC 1.1, where the discovery questions asked about assessing viable alternatives.
The company did not provide alternatives because they interpreted the question to only require a response if the alternative was considered viable.
The question was answered as it was written.
So yes.
Correct?
Thank you. Could the company, so I believe Mr. Simon alluded to the frequency of rate case filings. And isn't it true that the company currently does not have actual data for exactly how often the PFAS media exchanges are going to need to happen?
Referring to Ms. Fescher's testimony, that is being studied.
So it's not certain yet. It is still being studied.
We are certain that the costs are definitely going to need to be incurred.
But the frequency with which the PFAS media is going to be exchanged is not yet certain.
Correct.
And I believe in Ms. Fetcher's testimony, she stated that the company would have more data in a year. Is that correct?
Yes, the more we run the plant, the more information we're going to have about these costs. The issue, I believe, is that the frequency of rate cases, right? We could file, we'll probably have to file another rate case. From the company's perspective, we don't think that that's a great use of everybody's time and effort. That is why I believe Mr. Cagle had offered the surcharge mechanism in his original testimony. And if you were to look back at that testimony, the mechanism he had in there was basically a deferral account where after the fact, if there was any difference, right, between that reg liability and what was actually incurred by the company, that in the next rate case, we would work with the parties to refund that money back to customers. And so the thinking at the time was that a mechanism such as that would be better for all parties, including customers, and alleviate the need for additional rate cases in the near future.
The company would have more actual data had they waited a year to file a rate case. Is that correct? Regarding the PFAS O&M expenses.
Of course, we would have more data in the year, but that does not in and of itself dictate the timing of the filing of a rate case. Because as I stated in my testimony, as a company, we have to balance the needs of both public safety determinations and financial stewardship. We balance both of those things.
Thank you. That's all I have.
DPA?
Question.
Okay.
Nothing further, Your Honor.
Okay. Thank you. Okay, so we're done for today, and so I'm going to go off the record now.